হ্যালো। হ্যাঁ, হ্যাঁ, ওই 28 নম্বর কোর্টের সামনে এসে দাঁড়ান। হ্যাঁ, দাঁড়ান। ভাষায় সাহা কি করার নেই। ওখানে করেছিল, ওখানে না। এটা রেডি হবে। এক্সপেডিশন ডিসপোজাল 125 এন্ট্রিমেন্ট ব্যালেন্স কি কি পয়েন্ট যাবে বলে দেবো। হ্যালো, আপনার দিবসের পরের দিন আবার অর্ডার টেনে দিলেন।
হ্যাঁ, দেখছি দেখছি। ঠিক আছে।
আপনাদের আর ইন্ডিয়ার
এই তো পাতা দিবসের পরের দিন অর্ডার টেনে দিলেন।
ঠিক আছে সেটা বললেন
হ্যাঁ, কালকে যেন কটা দিচ্ছ?
আমাদের বাংলা করার কি জায়গা একটা জিনিস কোর্ট অমিট করে গেছে। বলুন। আচ্ছা, ওই আমাদের
আলোচনা হয়েছে দাদা 2 নম্বরটা কেন টু বি মেনশন? আমার ফেরার কোনো দরকার নেই।
মেনশনিং
হুম?
মেনশনিং
না না মেনশনই না, এটা 2 নম্বর হয়েছে বলছে।
আমি ঝাড় খাবো, তুমি আগে করো তারপরে আমি করছি। তুমি ঝাড় খাবো তো, কারণ আমাকে একবার ছাড়তে শুরু করলে তোমার মেনশনিং নেবে না, সুতরাং আগে করে ভিডিও আগে করে না। কতগুলো করবো একটাই, কিন্তু এদেরকে বলছি আগে তোমরা করে দাও, কারণ আমি মেনশনিং করলে ঝাড় খাবো। কেন খাবোই? আমি কিছুই করি না, কোর্টেরই ভুল। কি কোর্টেরই ভুল, আর বলা যাবে না ভুল আমাদের। কোর্ট বলেনি যে পাসপোর্ট রিটার্ন করতে, সেইটা রিল্যাক্সেশন, সেইটা তো বলেনি না। হুম। My lord, may I be permitted to mention one matter? My lord, your lordship was pleased to relax the condition of bail and permitted me to go to Bangladesh to meet my ailing cousin. My lord, my brother has deposited his passport and 50,000 surety. But my lord, the learned court below is not returning the passport, as my lord, there is no speaking direction to return my passport. My lord, great order টা দিব? I'm grateful to the steps.
May I be permitted to mention before your lordship, bail in connection with appeal.
Relaxation. Bail in connection with appeal. Defects be removed, adjourned 6 weeks. Lordship, time for the appellant. Next. Rajiv, no.
My lordship, I am here for the petitioner, my lordship. Accused is in the custody for more than 3 years, and the 4 of the co-accused, like 3 co-accused already has been granted bail, my lordship, in this matter. The 1 co-accused has been granted bail last week only.
Correct. Who is Mr. Moina Gupta?
But I am appearing on behalf of Who accused are on bail, he is on same footing. So we are releasing him on bail. Petitioner is in custody for more than 3 years. He submits there is slow progress in trial. Co-accused are on bail. He renews his bail prayer. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Bail prayer of the petitioner contents. Petitioner is in custody for more than 3 years. On the score of delay in trial, co-accused have been released on bail. Petitioner is entitled to similar relief. Accordingly, he is granted bail.
Oblige, my lordship. Oblige. Oblige.
Next.
Twenty-six kg, 23 kg, 100 grams of gaja from 2%. Custody for years. August 2022. Till date, out of total 11 witness, 6 witness has been examined.
Petitioner is in custody for 2 years, 2 months. He submits
6 months.
6 months. He submits. There is delay in trial. He renews his bail prayer. Do you renew? There
Lordship, in April 2023, my prayer
April it was rejected. Renews his bail prayer. Under such circumstances, learned lawyer for the state of 6 months. Only 5 witnesses have been only 6 witnesses have been examined. Prosecution proposes to examine 11 witnesses. There is no possibility of trial concluding in near future. Under such circumstances, we are of the opinion petitioner has been able to make out a case for bail on the ground of delay. Bail prayer is not fettered. Ravi Prakash.
Great.
Next.
Petitioner, this is my renewal.
I am appealing for the
I'm
Milord
playing
HCP
for
Milord.
bail on the ground of parity, standing on.
This is the report, Milord.
Another co-accused person granted. Page
Milord, on
41
so
of
far
the
on merit is concerned, Milord, your Lordship's Milord was not pleased to grant bail on merit, only on the ground of delay. Only on the ground of delay, Milord.
Mighty,
My lord.
after the bail granted to the other accused,
Yes, Milord.
has there been any significant progress
No, Milord, there has been, Milord, the next date is fixed on, Milord, 27th and 28th, Milord,
of
of the March, Milord.
March?
My lord.
All right. Petitioner is in custody for more than 2 years.
5 months.
5 months.
Co-accused has been released on bail on the ground of delay in trial.
Page, Milord, 41.
Petitioner is entitled to similar relief. এখানে বলো learned lawyer for the parties, learned lawyer for NCB submits report. We have produced the materials on record, including that report. তারপরে এটা দাও। Allowed.
Great.
Next.
Report release.
7, my lord, I am for the petitioner, my lord. Co-accused person was granted bail by the Honorable Supreme Court, my lord. That is at page 9, my lord.
Charge already. Before the Supreme Court bail or after the Supreme Court bail? My lord, bail was rejected on. Petitioner is in custody for
Custody for 2 years, 1 month, 10 days.
For over 2 years. Co-accused has been granted bail by the Honorable Supreme Court. Petitioner stands on the same footing. Said co-accused. Accordingly, we are inclined to grant bail to him. Next.
My lord, this is also, my lord. Co-accused person was granted bail by the Honorable Supreme Court.
Same
That is
footing, my lord.
paid.
Granted. Jalaluddin Sheikh has been granted.
Granted.
Petitioner is in custody for
1 year, 10 months, 12 days. 1 year, 10 months.
how long was this accused in custody?
But he has been granted bail on 2nd of February 24.
Were they arrested at the same time?
Yes, together.
For 1 year, 10 months, he submits there is Co-accused has been granted bail by the Honorable Apex Court. He plays for bail on parity. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Petitioner and co-accused stand on the same footing. Said co-accused has been enlarged on bail by the Honorable Apex Court. Accordingly, we are inclined to grant bail to the petitioner on parity. Allowed.
I am grateful.
Next.
For the petitioner. This is my renewal application. Now I am in custody for 2 years, 5 months. I am in custody for 2 years, 5 months. This is my renewal application.
After the rejection, trial has started, madam.
After out of 14 witnesses, one has been examined.
Fine.
One examined, others, my lord, date has been fixed
Petitioner is in custody for 2 years, 5
in
months.
the month of May.
Submits there is delay in trial. He prays for bail on the he renews his bail prayer. Learned lawyer for the state contained bail prayer of the petitioner was rejected in May 2023.
My lord.
Thereafter, trial has commenced. We have considered the materials on record. Bail prayer of the petitioner was rejected on merits in 2023. 2000 pieces of Yaba tablets was recovered from the petitioner, which is above commercial quantity. Eta bole tarpore bolo eta. However, petitioner has presently petitioner has prayed for bail on the ground of delay in trial. Full stop. Though petitioner is in custody for more than 2 years, only one witness has been examined. There is no possibility of
Yes,
In
ma'am.
the May of in the month of May, the other witnesses has been fixed. My lord.
there
Date
is
has
no possibility of trial concluding in near future. Delay in the matter is not attributable to the defense. Under such circumstances, we are of the opinion petitioner has been able to make out a case for bail on the ground of delay in trial. তারপরে যা বলে, bail is not restricted by fetters of 27 and in view of law declared in Ravi Prakash versus so and so, এটা continuously দিয়ে যাবে. Next.
Grateful. Lord, I beg to appear on behalf of the petitioner. My lord, this is the maiden application, my lord. I'm in custody for 2 years and 17 days.
Co-accused on 23rd of November with the direction to conclude the trial within 18 months, my lord.
My lord,
He is
the
standing on the same footing with the
my
person.
lord, the first date is fixed on, my lord, 30th April 2024.
Come after 18 months, will consider. Petitioner prays for bail. Petitioner submits he has been falsely implicated. He prays for bail. Learned lawyer for the state content. Bail prayer of co-accused was turned down in November 2023, and trial court was directed to conclude trial expeditiously, preferably within 18 months from the next date fixed for recording evidence. We have considered the materials on record. Petitioner stands on the same footing. We have considered the materials on record. 6550 bottles of penicillin syrup was recovered from petitioner and others. Bail prayer of co-accused Krishnapada Mondol was turned down by this court in November 2023. Petitioner and Krishnapada do not stand on the same footing with the other accused, Bashanti Mondol, who has been enlarged on bail by the Honorable Apex Court.
His prayer has been withdrawn from the apex.
Honorable Apex Court, prayer for bail of petitioner was not pressed before the said forum. Full stop. Hence, we are not inclined to grant bail to the petitioner on merits. On the score of delay, we note trial court has been given. Trial court was directed, we note, by order dated 24/11/2023 in CRM NDPS 1692 of 2023. Trial court was directed to conduct the trial expeditiously and conclude the same, preferably within 18 months. The time frame proposed by this court has not expired. Accordingly, we are not inclined to grant bail on the ground of delay also. Application is rejected. Next.
Made president. 11 I am appearing.
15 both are
Both
11 and 15 same case.
same case, different petitioner. Both made. They are made in bail application before your lordship. Both are in custody more than 2 years, 5 months.
First time.
Out of 12 witness, 8 witness has been examined. And my lord, last 2 occasion witness has not been turned up. My lord, the order shows that 53 is the date for further evidence. I have annexed entire order. March.
15th of 16 March.
We'll keep it after that. We are keeping the application pending. Please examine your remaining witnesses during that schedule. Petitioner is in custody for 2 years and
5 months.
5 months. He contends there is slow progress in trial. No witnesses turned up in the earlier schedule. Accordingly, he prays for bail. Learned lawyer for the state contends 8 out of 12 witnesses have already been examined. Next schedule has been fixed between 15th and 16th March 2024. In view of the aforesaid and to test the bona fides of the prosecution, we adjourn the hearing of this bail application till 19th of March 2024. Prosecution is directed to examine the remaining witnesses in the course of the next schedule. Report be filed on the adjournment. This is same order in 11 and 15. Both will be heard together. Both will be heard together. Next.
My lord, this is also made an application, my lord. I am in custody for 2 years, 4 months.
First thing. You should also bring that. Never use it. Next time you meet.
My lord, I am in custody for 2 years, 4 months and 10 days. There are total 10 witnesses. 14 dates has been fixed. Not a single date, my lord. Not a single date, my lord. Not a single witness has been turned.
How many witnesses?
10 witnesses. 10 witness, 14 days fixed. No prosecution witness come.
Days fixed. When was the charge frame?
My lord, charge frame in 19th December 2022.
19 December 2022. And
Charge sheet has been on way back,
right.
8th April.
And what is the quantity of narcotics recovered?
My lord, 100 bottles of Escaf cough syrup.
And you are in custody for?
My lord, 2 years, 4 months and 10 days.
Now tell.
This is second application that he has not.
No, second application. First application. First application.
Where is the second?
His application was rejected on 22nd of February 2022.
22nd of
February.
February. I don't think so.
No, my lord, this is the first time, my lord. It's a maiden application.
That transfers from the memo of evidence.
That transpires from the memo of evidence, but it doesn't transpire from the records of this court. Your memo of evidence may not be correct. Give us the CRM number. Give us the CRM number. Huh? We do not like memos of evidence like this until and unless you quote a CRM number.
Just now I have received CD, but
No, that is very good. But is the endorsement there in the case diary?
no, there is none.
Huh?
No.
Then why this statement is there that it was rejected in February 2024?
I couldn't clarify from the investigation officer because just now CD has been.
All right, tomorrow. Ask your officer to be careful. We are making it very clear. Don't make off-the-cuff entries in the memo of evidence. Whatever you feel,
No,
or
দশেরটা
you
দিয়েছি,
actually have reasonable suspicion, you make it. No.
Not today, man.
Tomorrow, let him clarify.
No.
For the
That is what we have.
from the house of one Joy Prakash, more than 1 crore rupees was recovered.
Brilliant.
And-
What is Joy Prakash?
And your lordship was pleased to grant bail to that Joy Prakash. And during investigation,
Why did we grant bail to Joy Prakash?
that order is at page 9.
Hmm. Oh, in the NCB case, Joy Prakash was not made an accused. Were you made an accused?
Accused, I was arrested in that case. In this case, my lord, there is nothing against me. And let
They are
him
the,
see
my lord,
what is there in
They are
this
the
case.
person, those who are
I was
procured the
arrested in this case.
injections from the market.
We are not going to give you bail. Petitioner submits that
1 year, 5 months in custody.
no narcotics was recovered from his possession. He is in custody for 1 year, 5 months. He pays for co-accused Joy Prakash Shah was enlarged on bail. He pays for bail. Learned lawyer for state submit. Narcotics was recovered from one Om Prakash. Narcotics was recovered from the petitioner. Prosecution was instituted against him by NCB as well as the state police. Full stop. We have considered the materials on record. Narcotics was recovered from petitioner. Prosecution was initiated against him by NCB. The aforesaid facts show his involvement in dealing in narcotics. He does not stand on the same footing with Joy Prakash Shah, who was not arraigned as an accused in the earlier prosecution. Under such circumstances, we are not inclined to grant bail to him.
Great.
From joint possession, 27 kgs of gaja was recovered. Custody for 1 year, 3 months. Charges same. Date has been fixed for trial.
Statements of witnesses and contemporaneous document, that is Caesar memorandum, show recovery of 27 kgs of gaja
From joint possession of
from
petitioner.
the joint possession of petitioner and co-accused. Full stop. Under such circumstances and in view of statutory restriction and 37 MNDP, that we are not inclined to grant bail. Yesterday registered there because me chief had organized.
My lord, I'm for the petitioner. I'm in custody for more than 7 years. On the last occasion, your lordship directed that the witnesses to be examined within 1 month.
Lordship, I'm praying for not today, Lordship.
My lord, I'm in custody for more than 7 years. On the last occasion, your lordship directed that the witnesses to be examined within 1 month from the date fixed before the trial court. Out of 19 witnesses, only 11 has been examined.
I'm praying for not today, Lordship. Pradip Ganguly is ill and has not come to court, Lordship. I'm praying for not today. There is an report to be filed. So I will not today. I'll inform him.
Much.
My lord, I am for the petitioner, my lord. My lord, 5 years I am in custody, my lord, without trial.
The vulnerable witnesses has already been examined.
All right.
Deposition.
জেলে আছে তারপরে
Petitioner is in custody for more than 5 years. He prays for bail on the ground of delay in trial. Learned public prosecutor opposes the submits. Vulnerable witnesses have been examined. We have considered the materials on record. Petitioner is in custody for a considerable period of time. Vulnerable witnesses have been examined. Under such circumstances, There is little possibility of trial concluding in near. How many witnesses left? Sonali
Well-
Das
12. 12.
left. 12 more witnesses are yet to be examined. There is little possibility of trial concluding in near future. Under such circumstances, we are inclined to grant bail. Allowed. What has happened to Mr. Nondi?
While on the morning walk, he was hit by a
No,
bike.
that day
Yes.
he was assisting you.
Oh,
Then
he
after
came
he
with
went-
the clip.
Now, what the doctor said?
Nothing serious, but I've been advised to take rest.
Take rest. He was a bike ran over.
He hit him.
In Newtown, how did it happen?
No, it's Baguyat.
Oh, Bagchi, right. He is in Bagchi.
Newtown more.
Oh.
Your Lordship goes at around 6 o'clock. From my house to Chingri Ghata, it takes now 1 hour. In the evening.
Evenings are bad. Evenings are very bad.
Post-COVID, the two-wheelers have increased many a times.
No, the more because evenings and mornings there is a big rush of office goers.
Yes.
The IT sector is completely.
Apart from the IT sector, most of the offices which were there in Dalhousie have shifted.
They're all shifted. They're all shifted. Right.
Claim করেছেন
Sector. Next. CBD. That is good. Now, radiator. Nobody wants to. There's a bigger problem. Report is placed on record, full stop. Report shows appropriate police protection has been given to the victim and the family members. She has been provided with a lawyer from the District Legal Services Authority. Compensation has been, prayer for compensation has been sent to District Social Welfare and Child Welfare Officer Barasat Northwest and Secretary District Legal Services Authority, Barasat North 24 Parganas, full stop. We direct the police authorities to ensure that the safety and security of the petitioner and her family members is duly protected. Concerned authorities shall process the prayer for compensation at the earliest. Full stop. Proceeding is closed. Next.
Well, this is
I am for the
the
petitioner.
mother and the. No, this is that matter, my lord, where the mother and her lover, my lord, had killed a small child of 4 years old. And your lordship had issued rule, my lord, because on the basis of affidavit, my lord, the lover was granted bail.
I'm for the petitioner, the accused person number 2, the mother of the deceased.
And who is for accused person number 1? Where is Ongshuman? Is your affidavit ready?
Yes, my lord.
Okay. We are giving you 1 week time, file the F9. On the prayer of the petitioner, time to file affidavit, on prayer of accused Abul Hussain Sheikh, time to file affidavit is
On the previous
uh,
occasion, your Lordship, on the previous occasion, you had mentioned that the two minor boys, their cross-examination should be completed. Their cross-examinations are complete. I'm in custody for more than 1 year now, Your Lordship.
let us
Will have kindly.
get this.
What
What
is
is
solicitized, my lord, and there are
also on the next day produce the evidence. Okay. Affidavit, time to file affidavit is extended by a week. Matter will appear 1 week hence. Evidence of the witnesses recorded in the meantime be produced before this court.
If Your Lordship is pleased, I have a certified copy, but
On the next day, we'll consider.
deep dive.
Are they exonerative?
no.
They are
Your
not.
lordship had
Then how does it help you? If they were exonerative, we might as well consider.
it was a game of 7 lakhs.
Then-
Madam, 302, 4 persons standing on a similar footing has been granted bail by your lordship. My lord, on the last occasion, it was adjourned for want of custody. Now I am in custody for 107 days. My lord, all 4 persons who have been granted bail, my lord, all of them are named in 164 as well as me. Page 7, 9, 11.
First, it was 133. It has
But-
gone down to 116. Now it has gone down to 107. Every time, lesser, lesser, lesser.
Jabbarul and General's order, my lord, does not show any
All right,
dates.
petitioner is in custody for 107 days. He submits the incident occurred in the course of a skirmish. Co-accused have been enlarged on bail. There is no chance of abscondence. Accordingly, prays for bail and a lawyer for the state opposes the bail prayer.
Well,
We have
the only
considered the
difference
materials.
is that he has been arrested on the strength of a arrest warrant of arrest. There's a difference.
Co-accused opposes the bail prayer. She submits. Petitioner had absconded and was arrested subsequently. We have considered the materials on record. Incident occurred in the course of a skirmish. Whether petitioners intended to murder the victim request to be assessed during trial. Co-accused are on bail. Full stop. Keeping in mind the aforesaid facts, we are inclined to extend grant bail to the petitioner.
Deep.
Well, 370, 4 and 6 of the POXO Act, my lord, on the last occasion, your lordship directed the jurisdictional OC to notify the victim. We have also on our own done that, my lord. This is my affidavit of service. My lord, the 161 of the victim and the 164 both say that she was in a love with a romantic relation with me, and she engaged in a physical relationship voluntarily. Her father came to know about it. He beat me up.
14 years, my lord. He was caught
What
red-handed.
is your livelihood?
I work in his
Romance.
father. I work in his father's concern, my lord. And his father therefore beat me up, my lord.
So therefore beat you up. What he should have done? Garlanded you. Huh?
Love, my lord.
Love. Now if he throws you out of that employment, where will you go? Love. You have no wherewithal. What is nature of work you do?
Well, I work in his father's shop, my lord.
Shop. This shop boy and owner's girl you are having affair. What do you expect?
169 days, my lord, I will custody.
Let him stay outside
He
jurisdiction.
caught red-handed, my lord, at the spot.
We understand he
And my
was
lord-
caught red-handed at the spot.
And
But-
what are
The girl
There
also
was-
admits
listen,
that.
my lord?
understand girl is a minor. He seduced the girl, etc. But he is also a young boy.
No, 33 years.
No. I'm 28. As per their charge sheet, I'm 28, my lord.
28.
Yes.
What are you doing with a 14-year-old girl? You are married,
No, not married.
not married. That is your saving grace. Petitioner is in custody for
169 days.
169 days. He submits there was a love affair between himself and the victim and the minor. He was falsely. Her father did not agree to the relationship, and he was falsely implicated. He prays for bail. Learned lawyer for the state opposes the bail prayer. Learned lawyer for the de facto complainant contends petitioner was caught red-handed in the act. We have considered the materials on record. Statement of the minor recorded before magistrate shows there was a love affair between the parties. Full stop. Possibility both the parties are young persons and possibility of cohabitation out of love cannot be ruled out. Under such circumstances, we are inclined to grant bail to the petitioner, but subject to strict conditions so that there is no adverse influence on the mind. 10,000 two sureties, petitioner while on bail shall not enter Salanpur police station.
I'm deployed.
Shall reside on. Now you see where you work.
Mine. I'm deployed. But my service may be kept with the এটা একটু রেকর্ডে রেখে স্যাটিসফ্যাকশনটা কাগজে লিখে দিই স্পেশাল কোড হবে
Messages to
স্পেশাল কোড হবে ডিপ্লি লিখে দে
Yes, Arindam Jana.
My lord, this petitioner, my lord, she is the reason for killing of her husband. She is in custody for 140 days. Charge sheet is filed, and all the other accused persons, my lord, they are in custody. And my lord, she is mother of 3 children, and the youngest is 5 years
When
old.
you were having affair with Paramore, you have forgotten 3 children.
Laid away with the paramour, brought back by her parents. Pregnancy had to be terminated.
Then what is
Her paramour, they conspired to kill her husband. One Ajijul was hired. Ajijul was paid money. There is a bank statement which shows that his paramour is transferring money to Ajijul.
Not me, my lord, I am only the Helen.
You are the
For me, my lord, they all
for me.
My lord, 3 children, the 5 years old is the youngest one. For 140 days,
Wait for some time. Mr. Public Prosecutor, what is there? We understand that she had an affair with the paramour. That there was agreement to kill the husband. Anything is there? That before the
pregnancy which was terminated was of the paramour.
How do you know?
But that is the case. And when it was terminated, she got infuriated.
my lord, my husband was always suspicious, my lord, about my relationship with one showman. My lord, who is my neighbor. My lord, I'm a mother of 3 children.
But showman has
Now, my lord, showman
is established.
Showman is directly involved in murder. Now, my lord, the money the transfer of this amount has been required.
Petitioner is in custody for 160 days. 140 days. She is the wife of the deceased. She is the wife of the deceased. She contends she had no role to play in the murder of her husband. She is the mother of 3 children. Accordingly, she prays for bail. Learned public prosecutor opposes the bail prayer. He contends petitioner had developed extramarital relationship with one showman. Full stop. She became pregnant and the pregnancy was terminated. This infuriated her and they entered a conspiracy to murder her husband. Showman transferred money to co-accused Ajijul, who murdered the victim. We have considered the materials on record. Petitioner had extramarital relationship with Showman. She had
she had become pregnant, which was illegal, which was terminated at the behest of her husband. She was infuriated and had motive to commit the crime. Uh, uh, these materials, prima facie, show her involvement in the conspiracy to murder. In view of the aforesaid incriminating materials, we are not, and gravity of offense, we are not. At this time. Next. 23.
I am for the petition.
Ashok Dasho.
The case was under section 14A B of Foreigners Act 12 Passport Act.
This is the verification report, my lord. It's a fake one.
Report is placed on record. I have original Adar's identity card relied upon by the petitioner is fake. He is a foreign national. In view of the aforesaid incriminating materials and nature of offense, we are not inclined to grant it. Next. 24.
My lord, I am appearing on behalf of section 498A 325 34 of the Indian Penal Code. I am the husband, my lord. Other persons are granted anticipatory bail in custody for 41 days.
My lord, husband beaten by the wife with the iron rod.
All right. Petitioner submits that he has been falsely implicated due to domestic dispute. Further, he prays for bail. Learned lawyer for the state submit. Petitioner husband had beat the wife with an iron rod. We have considered the materials on record. Petitioner is in custody for 41 days. Further detention for progress of investigation is not necessary. Under such circumstances, we are inclined to grant bail. Next.
I'm for the petitioner. Lordship, the case is under section 302 of the IPC, Lordship. Altercation took place due to auto fare, Lordship. I am a auto driver, Toto driver. I took him to the hospital, Lordship.
You murdered the passenger.
Yes. Lordship, I did not murder the passenger, Lordship. As per my instruction, the Toto turned over.
Toto turned over.
That is the charge sheet submitted. I am in custody for 112 days, Lordship.
Absolutely no. Petitioner is in custody for 112 days. He submits. He is a Toto driver. There was dispute over fare and he had no intention to murder. He prays for bail. Learned lawyer.
It's a eyewitness.
Forget about where did he hit? Head.
Head. With a range. With a range.
That we have seen. We have considered the materials on record. Petitioner had hit the victim on the head with a wrench. That is iron spanner. Spanner. Good stuff. As the assault was on a vital part of the body, with a weapon like substance, we are not inclined to grant bail to the petitioner at this stage.
Grateful, Lordship.
Next.
My lord, I am for the petitioner.
Yes.
My lord, my prayer for bail was rejected on 9th of June 2021. That is at page 10. And my lord, that time this honorable court was pleased to direct the learned trial court shall conclude the trial by 6 months. My lord, charges were framed on 16th of March 2020, but till date no witness had been examined. My lord, all other co-accused persons were granted bail. The one Robi Turi, that is at page 14. If your lordship kindly sees, my lord, that he was granted bail with whom, my lord, the wife of the deceased had an...
We have considered the materials on...
no,
One of the delays because after being granted bail, they are absconding. Warrant has been issued.
On...
Have you got the report?
My lord, no conclusive report. We don't have a
petitioner. Get a report. Petitioner is in custody for
4 years, 6 months.
4 years and 6 months. Other co-accused are on bail. He contends in spite of direction given by this court in
page 10
in CRM 701 of 2021 to conclude trial within 6 months. There is no progress in the matter. Accordingly, he renews his bail prayer.
State shall submit report with regard to status of proceeding on the adjourned date, adjourned 1B.
My 1 minute.
Next,
Grateful.
Kalidas.
Not facing this application.
Pressing.
Well, I have missed it. Well, there is a rejection. Well, 3 years, gal, my lord.
Yes, Gal.
960
Not
days.
face. Yes, 28.
Milord, offense under section 300 to 201, Milord. Suspect that the petitioner murdered his wife, Milord. Milord,
Petitioner murdered his wife.
Milord, complaint. Suspecting. And Milord, kindly see the
Who is going
evidence.
to murder your wife?
No, Milord, kindly see the evidence of PW1, Milord, page 15, Milord. Milord, they are residing in a red light area. And Milord, red light area. And Milord, kindly see the evidence of PW1, Milord. Kindly see, Milord. They are prosecution witness petition number PW1, PW2, PW3, PW4. Complainant and 3 co-tenant. They did not support the prosecution case.
Where the wife died?
Yes, my lord.
Where the wife died?
Flat. Room.
Who was in the room?
Milord, up to noon, Milord, petitioner was with the wife. Milord, it was detected at 6 p.m.
Then
6 p.m. But Milord, kindly see the evidence of PW1, Milord. 4 years, 10 months I am in custody. 4 years, 10
how
months.
many witnesses left?
Out of 13, 5 already examined. And no one supported the prosecution case.
What is what is to be supported? Are you relying on any eyewitness version?
No.
It's a circumstantial evidence.
It's a rented room. She was
They used to
murdered.
stay together. She was found murdered.
She was murdered.
Then
He left for Calcutta.
For a moment, Milord, kindly see the evidence of
for a
PW1.
moment,
Milord,
we
for a
have
moment.
seen everything. But when there are circumstances which show that you were the only person who ordinarily resided with the victim, and the victim is found dead, murdered in a room,
Yes, Milord.
then until or unless you establish an alibi, it will be difficult for you to rebut.
Co-tenant also.
That will be seen. Establish your alibi. We are directing Mr. Roy, please give a report. We are keeping this pending as to a timeline within which you propose to examine. Petitioner is in custody for
4 years, 10 months.
4 years, 10 months. He submits there is no direct evidence implicating him in the murder of his wife. Only 5 witnesses have been examined. He prays for bail. Learned public prosecutor is directed to submit report with regard to status of the proceeding, as well as a timeline within which prosecution proposes to examine remaining witnesses adjourned 1 week.
Milord, political dissident and difference, Milord. Milord, on 15 June 2023, Milord, the last date of filing. Yes, Milord.
Then
now, Milord, FIR named Milord.
Then?
But what was my role, Milord? 112 days, Milord, in the custody. Milord, there is no iota of Milord.
No iota.
Milord, we Milord, so far as Milord, so far as my client is concerned, Milord, he belongs
How
to
many named in the FIR?
Milord, 51.
51 accused named in the FIR.
No such. Nausad Siddiqui and others, the local MLA. Milord, he is a member of Legislative Assembly, Milord. His name was also there. And they said, Milord, that the conspiracy was hatched. And Milord, the person, Milord, who was murdered on the day, Milord, the victim belongs to Trinamool Congress, Milord. And Milord, everybody assembled, Milord. Milord, the workers of the TMC, Milord, ruling party, Milord, they were without arms. And my client, Milord, who belonged to a particular political party, he was armed with, but there was no role, Milord. In the FIR, if your lordship, Milord, kindly takes pain, Milord, to go through the FIR. There is no role assigned to my client. Nothing. Only Milord 47. Charge sheet has been filed, Milord, against Milord 31. Now, Milord, the question is, Milord, that so far as the kindly sees the FIR, Milord 47, Milord page. And I participated in the investigation. 3rd November 2023, I was called.
What participation you
Well,
did?
participation means, Milord, I was called, I went to police station.
And they arrested you.
Yes.
And then you are with the police.
Milord, kindly sees, Milord. 47, Milord, that is the complaint.
Why this is an FIR sort of, everyone is named, any overact over as
And
I'm telling you, let
no,
him
Millard,
finish.
kindly seize Millard the page 62, Millard.
বাইরে গিয়ে বলবে criminal মামলা করতে এসেছি বলে
page 62.
Yes, Millard, kindly take Spain, Millard, turn to the last paragraph. In course of investigation, 21 accused persons have been arrested and 4 persons have been shown arrested so far. During investigation, it has been revealed that on 15/6/2023 was the last date of filing nomination of the Panchayat election. Over the issue of filing of nomination, tension was prevailing under Kashipur and Bhangor PS area. On the previous days of filing nomination, both the supporters, ISA and TNC parties were engaged in quarrel between them and numbers of people got injured. On such and such 15/6/2023, that is the last date of filing nomination, Nausad Siddiqui, MLA of Bhangor, went to Majerhat village under Kashipur PS and he organized a meeting on that date at such and such with his followers of ISA party in front of his party office. At that time, Nausad Siddiqui gave specific instruction to his followers that they had to file nominations of their candidates for the seats of Gram Panchayat and Panchayat Samiti and ensuing Panchayat election at any cost. For that purpose, number of leaders and supporters of the ISF from different places gathered at Ganirhat and Panapukur village, more under Kashipur PS area, armed with bombs, lati, such and such iron. Some supporters of TMC party who also were gathered at different places and Vijayganj Bazar, Panapukur, more or at Ganirhat, more with a view to take part in the rally of their party during. They assembled for peaceful purpose, and Millard, so far as ISF is concerned, Millard, we raised voice against them, Millard. So we were the persons, Millard. Kindly cease. And what was the statement, Millard, made by the leader, Millard, of the party, Nausad Siddiqui? Whether, Millard, it incited people, Millard, to cause violence or Millard?
Nausad Siddiqui is not before us.
No, but the question is, this is the point that he incited, Millard. That is one of the ingredients, Millard. The logic, Millard, that we on the date.
You are not arguing for.
No, I am not. I am saying, Millard.
If someone doesn't incite you, it doesn't. It may exonerate that person. But what is your role?
That is also absent, conspicuously absent.
Correct.
And that is the conscious omission.
You are not arguing for Nausad Siddiqui.
No, I am not. I'm
Has
saying.
Nausad Siddiqui been charge sheeted in this case?
No.
Huh?
No. Nausad Siddiqui, MLA. Yes, that is he is also.
So if Nausad Siddiqui prays for bail, we will.
No, I will not. I am not, Millard, espousing, because I am saying, Millard, that the logical end.
You were there with arms and weapon.
Yes.
Someone had thrown a bomb.
Not a single line, Millard, that has been invested for my client, that Jahangir Ali, that is the petitioner before your lordship, Mali. Millard, what is my role? If I do not wish to destroy.
Please see the FIR.
Yes, Millard. The kindly see 46. What is the language? 47, Millard, sorry. আমি ঋত্বিক নস্কর, পিতা চুনিলাল নস্কর, গ্রাম হাটগাছা, থানা সাচানসাচ, আপনাকে জানাই যে 15/6/2023 তারিখে পঞ্চায়েত নির্বাচন নমিনেশন করানোর জন্য আমি আমার হাটগাছার কিছু বাসিন্দা ও আমার শ্বশুর রাজু নস্কর ভাঙড় 2 নম্বর ব্লকে যাচ্ছিলাম। আনুমানিক বেলা 2টো নাগাদ পানাপুকুরের কাছে আমাদের উপরে দুষ্কৃতী হামলা সংঘটিত হয়। ভাঙড়ের ISF বিধায়ক নৌশাদ সিদ্দিকী ফুরফুরা জেলা চক্রান্তের প্ররোচনায় হামলা সংঘটিত হয়। দুষ্কৃতী দল আমার এবং আমার শ্বশুর রাজু নস্করের উপরে পানাপুকুরের নিকট হামলা চালায়। বোমা, বন্দুক, লোহার রড, বাঁশ, পাথর, টাঙি, তরোয়াল সঙ্গে নিয়ে আমাদেরকে ঘিরে ফেলে। ISF এর দুষ্কৃতী দল আমার শ্বশুর রাজু নস্করকে চারিদিক থেকে ঘিরে ধরে মাটিতে ফেলে মারতে থাকে, সারা শরীরে লোহার রড, পাথর দিয়ে মারতে থাকে। বাঁচান।
These are allegations.
These are allegations.
And the names of the persons who had assembled there is given at the bottom.
Yes. Now, Millard, he concealed himself, Millard, immediately within a
public prosecutor. Let us see what is the material collected against you. Correct.
I did not, I was always, my lord, lending my meaningful hands to the investigation. I never concealed myself. I never, I disdained to conceal.
We will be looking into your complicity, then we will look into your cooperation. Yes.
My lord, it was the last day of submission of अरे बाबा दाঁড়াও না কত উৎসাহী কেন
Nomination.
The local political leader called a meeting at his party office, asked all the followers, whatever happens, I will take care of that, but we will have to file nomination. A mob armed with bombs, firearms, started for the BDO office. On the way, they met their opponents. There has been 3 deaths. One of this is before your lordships, there are 2 other deaths also. There are other cases. Your lordship will find.
Is he an accused in those cases also?
The other case also, he will be an accused because the same procession is going.
No, has he been arrested in those cases?
Yes, no.
Then he is not arrested, so he is not an accused in those cases.
But,
There are 4 accused, which is common, Mr. Rai. As per what was shown to us, you'll find 21 accused here and 4 shown arrested. That means those 4 are in another case. So the commonality of the participation in similar activity relates to these 4 persons.
But so, and his presence, my lord, not only in the FIR, but at least 1, 2, 3, 4, 5, 6, 7 people have said about his presence in that mob from the party office towards the place of occurrence.
Mob. All right, take the petitioner is a member of a political party. On the day of a member of a political party, he contends on the day of occurrence, he, along with the other supporters, were proceeding to file nomination paper, were proceeding to the BDO office to ensure their candidates are able to file nomination papers for the panchayat election. A group belonging to a rival political party intercepted them.
Intercepted. They were there.
Confronted them. Full stop. Some of them confronted them. Full stop. It is alleged that there was a skirmish and one Raju Noshkar, a supporter of the rival political party, expired. Full stop. Petitioner, though presence of the petitioner did not, no overt act is attributed to the petitioner, and he did not share common object to commit the murder. Good stuff. He has not been implicated in any other criminal case. He does not have criminal antecedents, and accordingly, he prays for bail. Learned public prosecutor opposes the bail. He contends one Nawaz Siddiq, a leader of the political party, had incited his supporters.
Naushad
Siddiq had incited his supporters to resort to violence. Full stop. Pursuant thereto, a group, an unlawful assembly was formed. Petitioner was a member of the unlawful assembly and was armed. Members of the unlawful assembly threw bombs, resulting in the death of Raju Noshkar. Full stop. Raju Noshkar. Similar deaths had occurred in the locality on the same day, and other cases have been registered.
Accordingly, he opposes the bail prayer. We have considered the materials on record. Allegations in the materials on record, including the FIR and the charge sheet, full stop. Allegations in the charge sheet show Naushad Siddiqui, leader of a political party, had held a meeting on the fateful day. In the course of meeting, he exhorted his supporters to submit nomination papers at any cost. Full stop. Right to submit nomination papers is a democratic right. Exhortation on such score per se may not amount to incitement to form unlawful assembly. Full stop. Be that as it may, allegations in the first information report show an unlawful show a large number of members, a large number of supporters of the said political party, being variously armed, proceeded to the BDO office to submit nomination papers. In the course of in the way, they met with a group of supporters of another political party. It is alleged the members of the political party, it is alleged some of the supporters of the petitioner's party threw bombs, resulting in the death of one Raju Noshkar. Stop. It is unclear. It is unclear. It is not. There is no allegation that petitioner had actually thrown bombs, resulting in death. Full stop. However, resulting in death. However, public prosecutor argues he has been charged with. He argues that he was a member of the unlawful assembly whose common object was to commit murder. Full stop. Assembly had been formed. Assemblage of persons had taken place on the exhortation of the leader to file nomination paper at all costs. Full stop. The object of the assembly being such, it is debatable whether it could be defined as an unlawful one at the outset. We are not unmindful of the fact that a lawful assemblage of persons may turn unlawful due to the activities of its members. The stage and circumstances in which such alteration takes place is a matter to be decided in the facts of each case. Full stop. Noting these circumstances, we are of the opinion, as the assemblage of persons at the outset, as it is debatable that the assemblage of persons at the outset was unlawful or not, mere membership without anything more may not be sufficient to foist constructive liability on the petition. Full stop. Constructive liability on the petition. It is also relevant to note, petitioner has not been cited as an accused in the other cases of similar nature which occurred on that day. Full stop. Under such circumstances, we are of the opinion, in view of the extent of involvement of the petitioner in the crime, we are of the opinion the issue whether he was a member of the unlawful assembly and shared its common object requires to be assessed in the backdrop of attending circumstances during trial. Petitioner has no criminal antecedent, and there is no possibility. Petitioner has no criminal antecedent. He has permanent home and hearth, and there is no possibility of abscondence. Under such circumstances, we are inclined to enlarge the petitioner on bail subject to conditions. Petitioner while on bail shall not enter Kashipur police station. You stay in a Kashipur police station, right? Shall not enter Kashipur police station. 10,000 to sureties shall not enter Kashipur police station until further orders. Shall provide the address where he shall stay to the investigating agency at the court below with the officer in charge. So and so on.
CGM বাড়ি পড়লি
Let him also provide his mobile number.
He shall provide the mobile number, mobile number of the petitioner shall also be provided to the petitioner to the investigator. Mobile number used by the petitioner while on bail shall be intimated to the investigating agency for necessary surveillance.
Yeah, well, I'm renewing my prayer.
They are going, these guys are confronting. Their assembly becomes unlawful. So at what stage it becomes an unlawful assembly, we have to examine that.
Lord, I'm renewing my prayer for bail. My Lord, I am in custody for 1 year, 3 months. My Lord, charge sheet has been submitted. My Lord, 6/9/2023, my Lord, TW1 was examined in part. Thereafter, my Lord, on 3 occasions, no witness turned up. And my Lord,
Has
there
been examined.
no, my Lord. My Lord,
Victim has been examined.
not yet.
So we don't wish to examine, reconsider your bail prayer before that. Bail prayer of the petitioner was rejected earlier on merits. Good stop. Victim is yet to be examined. Under such circumstances, we are not
direction for
inclined to
day-to-day.
grant bail to the petitioner at this stage. We request the trial court to take necessary steps for examination of the victim at the earliest. Parties shall communicate this order to the cooperate with the trial court and communicate to the order to the trial court for due compliance.
I'm grateful.
Yes.
Lordship 31, I'm for the petitioner. Lordship, I am renewing my prayer for bail. Lordship, petitioner is in custody for 713 days. Lordship, first I am making my submission in regard to the 161 statements, Lordship. Lordship, there are 7 persons who only stated that they found a dead body of an unidentified cutthroat woman is lying in the water at Kongshaboti riverbed, but they don't know anything about the incident, Lordship. 7 witnesses are such kind.
Charge has been framed.
Charge has been framed, and after framing of charge, one of the accused has claimed that he is a juvenile. He was sent to the juvenile board, and report was called for as to the effect that whether he is a juvenile or not, and that is why trial has been stalled up.
Yes.
Lordship, then out of the 9 persons who have stated they have knowledge about the incident or have suspicions that who will be the accused, Lordship, out of those 9 persons, 6 persons have not stated the present petitioner's name.
3 stated.
6 persons have not stated.
But 3 stated.
3 stated. And
how do you get over those?
Lordship, out of those 3 persons, they have never stated that last day they have seen me with the other 2 co-accused. They stated that they 3 were rented on that accommodation. They stayed together. They know that this person have terms with the lady, but they have never stated that the last day they saw me with the lady. Lordship, that is the 161 statement. And Lordship, out of 164 statement, there are 6 164 statements. Out of them, 4 have not stated my name. 3 of them are the relative. They never make any whisper about my name. 1 has stated that he saw 3 persons were there last night with the lady. 2 of them, he cleared the names. They named clearly the name of the other 2 co-accused, but my name he has not stated. Only 2 persons, then Lordship, took my name. And Lordship, if you kindly see the 161 statement and 164 statement, this also contradictory. There. And Lordship, kindly.
Well, even pursuant to his leading statement, The weapon of offense has been recovered.
Lordship, all the
What about the last scene together?
But can you see is 164 at page 65. Yes, page 65. Relevant portion is just page 65.
This is one. Another?
That's on 69. My lord, can you see?
'69 is nothing incriminating. It is suspicion. 65, yes, we understand. 65 is the son of the owner of the.
Yes, and page 161, page 22.
The father's statement is there. Ishwar's statement is there.
No.
Oh, Ishwar Tarapada. So he's dead.
My lord, page 22, 161 statement. And after rejection of the third application for bail, charge has been framed, already framed. And my lord, your lordship will kindly see from the Caesar list that leading to the statement of this accused, not only the weapon of offense, but the belongings of the deceased has been recovered.
16.
Page 54 is the leading statement.
Yes.
Of the this accused, and pursuant to such leading statement, kindly see the Caesar at page 71 and 73. You know, the personal belongings, the jewelry, and the weapon of offense has been recovered pursuant to the leading statement.
'73.
71 and 73 are the two Caesar list.
This person is Shamim Ahmed.
Sheikh Shamim Ahmed. His leading statement is at page 54.
71 is also leading statement. Petitioner contends that there is no direct evidence connecting him with the murder. Full
Lordship,
stop.
Lordship, kindly see the seizure, Lordship. 2 mobile phones were seized, 3 mobile phones were seized, but not the present petitioner's mobile phone. By which, whether I am present or not, police can track. But Lordship, that has not been seized. Only those 2 persons' mobile phone were seized. And Lordship, secondly, Lordship, kindly see the statement of the other co-accused. Everywhere they stated, we are the persons, we too committed this offense. They never stated the present petitioner's name.
But then can that be used in your defense?
No, Lordship.
You cannot use it because prosecution will not be able to cross-examine them.
But Lordship, 164 statement of Subhashis Jana.
Your leading statement leads to the recovery of the earring of the deceased.
Lordship.
Okay. Petitioner is in custody for connecting him with the murder. He has been falsely implicated in the case. He renews his bail prayer. And a lawyer for the state opposes the bail prayer. He contends the bail prayer of the petitioner was rejected earlier on merits. Charge has already been framed. Full stop. We have considered the materials on record. Statement of the owner of the son of the owner showed that the victim had come to the tenanted apartment occupied by the petitioner and co-accused. Thereafter, her body was recovered in the river. On the leading statement of petitioner and co-accused, weapon of offense as well as an ornament, that is earring, of the deceased was recovered. In view of the aforesaid incriminating materials and gravity of offense, we are not inclined to grant bail at this stage. Next.
P76 511. Petitioner is in custody for 54 days. Both are resident of the same village, they are neighbors. Allegation is that at night.
Can you see the 164 statement?
164 statement. ये दोनों आप आधा ले सकते हैं. Public prosecutor. You're dirty sort of a person. Very uncivil and unsocial behavior.
That is the allegation. Only one day at the bathroom at 9 a.m. When she was in the bathroom, I entered into the bathroom. That allegation, kindly appreciate that.
Okay. Petitioner submits that he has been falsely implicated in the instant case. Charge sheet 5.
Yes, sir.
Investigation is complete. He prays for bail and a lawyer for the state opposite the bail prayer. We have considered the materials on record. Petitioner is in custody for
54 days.
For about 2 months. Investigation is complete. There is no chance of absconding. Accordingly, we are inclined to grant bail.
Is it in there?
What to do this Surana thing to at 2 p.m. now. Let us see bail in connection. नहीं करेगा. It's it after. Let me go and what Kollan month for Yes, bail in connection with appeal.
46.
In this matter, Lordship, I am appearing on behalf of the appellants. This is the renewal of the bail after 8 years. Actual imprisonment more than 10 years. And paper book is not ready as because LCR is lying for the trial court as because the split trial is going on. And out of 31 witnesses, only the 3 witnesses have been examined. And there is no chance of early hearing, Lordship.
Alright.
There are statements of eyewitnesses, two persons were.
First, let us see, get a report from the trial court, time frame within which the trial of the absconding accused shall be concluded, right?
Trial concludes, this appeal will conclude.
No.
Absconding.
Absconding accused. Get a report, huh? Learned lawyer for the appellant submits he is in custody for over 8 years.
10 years, more than 10 years.
More than 10 years. Lower court records have been remitted to the trial court for trial of absconding accused. Paper books have not been prepared. There is no possibility of appeal being heard out in near future. Under such circumstances, we direct the trial court to submit a report stating the time frame within which the trial of absconding accused shall be concluded. Stop. May be concluded. Copy of this order be transmitted to the trial court for due compliance. Matter will appear 6 weeks hence.
Obliged.
Well, I'm led by Miss Oshima Mondla. She's on through VC, Your Lordship.
Yes.
May please, my lords.
Yes.
My lords. My lords, I beg to appear for the petitioner, my lords.
Yes.
Please, my lords. My lords, this is a CRAN, my lords. My lords, the petitioner has been under custody for 7 years, my lords. And my lords, there is non-compliance of section 52A, my lords. And this,
Yes.
please, my lords.
7 years out of 10 years.
My lords. 7 years out of 10 years, my lords. He's a 75-year-old man, my lords. And my lords,
What do you say? Are paper books ready?
my lords, paper book is ready. It's before your lordship, my lords.
For pending hearing, right? All
Yes.
right. Appellants are in custody. Appellant is a septuagenarian and in custody for 7 years. He has been sentenced to a term imprisonment of 10 years. He renews his prayer for suspension of sentence. Learned lawyer, what do you say?
My lord,
Acha, arekta line. It is also contended that the samples which were examined by the samples examined by the chemical examiner had not been inventorized in the courts, had not been collected before magistrate as per section 52 capital A of NDPS Act. Yes.
my lord, there is no denying that the substance was recovered from the accused, which is above commercial quantity for.
Your non-compliance of samples being drawn before magistrate, what will be its impact? We will have to see.
My lord, which is why it is very closely linked to the trial that had occurred. And therefore, my lord, if this bail application could be heard in conjunction with the appeal hearing, my lord.
7 years already under. We have considered the learned lawyer for NCB, right?
My lord, Customs Department.
For customs submit that the samples were drawn. Samples at the spot were drawn contemporaneous to the. Was there any certification under 52 capital A?
No, my lords. No, my lords. They admittedly, my lords, the PW, who the IOs, also the raiding team, PW 2 to 4, they specifically say that, my lords, we were not aware that anything before the magistrate had to be done, my lords. They seized the samples, my lords, took it back to the customs office, and then, my lords, sampled it in the department, in the office of the deputy commissioner, my lords. It's an admitted fact where they say we were not aware of 52A, my lords.
Very good. We have considered the evidence on record. Samples were drawn at the spot and the chain of custody has been clearly proved. Hence, no prejudice has been caused to the appellant. Appeal is ready for hearing. We have considered the evidence on record. No, there is non-compliance of Section 52, capital A of NDPS Act. It samples examined by the chemical examiner was not drawn in presence of magistrate. This issue requires to be assessed during hearing of the appeal. Appellant has already suffered 7 years, more than 7 years of rigorous imprisonment. Sentence is one of 10 years rigorous imprisonment. Under such circumstances, we are inclined to suspend he is a septuagenarian. Under such circumstances, we are inclined to suspend the sentence of the appellant and enlarge him on bail. Allowed.
Grateful, my lords. Deeply allowed.
Appeal appear in the monthly list of April 2020.
Grateful. Grateful, my lords.
Never applied for bail. Subsequently, we find this just happened from the spot. The game is यही तो प्रॉब्लम है going this way. Sandeep is sitting with you. I know.
My lord, I'm appearing for the appellant, my lord. I'm in custody for 8 years, 3 months. Life imprisonment under section 302. I'm renewing my prayer for bail, my lord. My last petition was,
Yes, we'll add the matter for listing.
my lord, for the hearing of the
For
appeal, my
hearing,
lord.
finally.
Huh?
Not now. This is a life imprisonment.
Life imprisonment.
So until and unless 12 years or 10 years, we are not going to suspend the sentence.
Well, there's one just one page, one pager from the Honorable Supreme Court, my lord, where 7 years has been considered.
Appellant contents, he is in custody for 8 years.
3 months.
More than 8 years. He submits. He renews his prayer for suspension of sentence. We have considered the materials on record. Bail prayer of the appellant had been turned down early.
December 2021, my lord, at page 10.
December 2021 on merits. On the issue of delay in hearing, we note paper books are ready. Paper have been prepared and appeal is ready for hearing. On the issue of delay, we note paper books are prepared and appeal is ready for hearing. Sentence is one of life imprisonment. Under such circumstances, we are not inclined to suspend the sentence of the appellant. We direct the appeal to be listed in the under the heading hearing in the monthly list of March 2020.
To grant a specific date.
Not now. Let it come up. When it is called, please ask your junior. We will start the hearing.
My lord, item 49, I am for the appellant. My lord, I have filed this appeal in 2021, but in my grant application, there has been a mistake done on my part. The identity of the victim has been disclosed in the petition, my lord.
Make the changes.
My lord. And my lord, victim has also not made a party, my lord.
Appellant is directed to redact. 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 Or you withdraw the application and file.
My lord, my lord.
Appellant seeks leave to withdraw the application and file a fresh. Liberty is granted.
My lord. Grateful, my lord.
Lordship, I am appearing on behalf of the appellant. And appellant is in jail for last 20 years.
Paper books be prepared and placed before this court. Adjourned 6 weeks.
Lordship, obliged.
देखिए 2013 में conviction है 22 में appeal किया and now he's saying 20 years. Dismiss करो.
Milord, I am for the appellant. Milord, the appellant is in custody, Milord, about 9 years. Milord, the case of the prosecution is that, Milord, that the mother had lodged this FIR, stating that on the day of incident, she was outside the veranda, on veranda outside the room, and the son was inside the room. Milord, the son came out for, Milord, respond nature's call. Milord, then, Milord, the appellant had, while he was returning, the appellant had given a blow on his neck. Milord, she further stated in the FIR that he had an immoral relationship with this appellant last 8 to 10 years, and she used to stay at her father's house at Bogula. Milord, this is the first information report. Milord, in the inquest report, Milord, the wife had categorically stated that the incident had taken place while her husband went to answer nature's call. While returning, some unknown person had committed the offense. This is the wife who stayed with her. Milord, Milord, if your lordship sees the evidences, Milord, the mother, Milord, had in his deposition, Milord, in the FIR, she stated one thing. In deposition, she categorically stated that I have no relationship with these accused persons at any point of time. Milord, the other witnesses, Milord, the one of the neighbors, he came and deposed as PW3. Milord, stated in his evidence that on that night, Milord, he did not see Monimala, the mother of the deceased, in the house. Milord, the another witnesses also, Milord, the uncle of the boy, the deceased, he also examined in court. He categorically stated after hearing the hue and cry, he rushed to the house and he saw some persons, they are assembled there, and the person was sustaining bleeding injuries lying on the courtyard. But he also not took the name of Monimala regarding her presence on the place of occurrence at the relevant time. Milord, the investigating officer categorically stated in court, Milord, that he inquired, he came to learn, he inquired regarding the presence of Monimal.
What about the wife? Wife of the
Wife, Milord, categorically stated in, though Milord, the wife declared hostile, wife's statement to the effect that my mother-in-law had never stayed with us. The mother-in-law stayed at her father's house at Bogula. And Milord, the incident had taken place. She was present in the house, but she could not identify the person who had committed then unknown person had committed this offense. Milord, your lordship, kindly see Milord, the evidences produced before the court. একটা আছে, তুমি দেখো, আমি তোমার নয়
Appeal is paper books ready?
No, Your Lordship. Paper book ready? No, Your Lordship.
Milord, your lordship, kindly see the evidence of PW3. Milord, he is the neighbor. Immediately came to this place. He not stated that, Milord, nobody, the witnesses claimed PW1. Nobody had, Milord, recognized that PW1 stayed in this house.
But the hostile witness, that is the wife of the deceased, admits on that day mother-in-law was in the house. Hence, that is corroborates PW1.
Milord, Milord, if your lordship kindly see the cross-examination, Milord, the wife, in my matrimonial house, I used to stay with my husband and brother-in-law, and my mother-in-law used to stay in her paternal house at Bogula.
Very good. But on that day,
she
was
of
there.
the incident, my mother-in-law was in her paternal house at Bogula. Milord, the incident took place. Milord,
paternal house at
my lord, incident took place about, Milord, 45 kilometers away from the paternal house. Milord, your lordship, kindly see nowhere any of the witnesses claimed that the mother-in-law was, Milord, the PW1 was present in the house on that very day. Moreover, in first information report, PW1.
Appellant is in custody for 9 years. He submit PW1, the sole eyewitness, did not ordinarily reside in the house of the deceased. Her presence at the PO has been disputed by other witnesses, that is neighbors PW2.
Milord, the neighbors PW, Milord, 3.
By other witnesses, that is neighbor PW3 and wife of the deceased.
Milord, PW 5.
And
PW5, wife of the deceased. Paper books are not ready and there is no possibility of appeal being heard in near future. He prays for suspension. This is first time he prays for suspension of sentence. Why 9 years you were in custody? You were in custody during trial.
Yes, sir. All along he was in custody. Your Lord. All along he was in custody.
We are learn a lawyer for state.
He was arrested on 2015.
Being heard in the near future. Full stop. Learn a lawyer for state opposes the prayer. She submits PW1, mother of the deceased, stated she saw the appellant assault her son. She also disclosed assault her son, resulting in his death. We have considered the evidence on record. PW1, the sole eyewitness, is the mother of the deceased. In the FIR, she claimed she ordinarily resided at her parental house and not with the deceased. Full stop. She also claimed appellant had an illicit relationship with her earlier. After she had withdrawn from the relationship out of grudge, appellant murdered her son. Full stop. Though in court, PW1 wholly denied her previous relationship with the appellant, which destroys the motive to commit the crime. Her presence at the place of occurrence is disputed by another witness, is disputed by PW3 neighbor and PW8 wife of the deceased. PW5 wife of the deceased. Though PW5 was declared hostile, PW5 was declared hostile, prosecution did not declare PW3 as a hostile witness.
And he is the Caesar witness also of the printing method.
Under such circumstances, there are contradictory versions are emerging with regard to the presence of the most vital witness, PW1, at the place of occurrence. On the other hand, wife of the deceased claimed that her husband was murdered by unknown persons. Full stop. An arguable case in favor of the appellant is made out. Now, in view of this palpable lacuna, an arguable case in favor of the appellant is made out. Appellant is in custody for more than 9 years. There is no possibility of appeal being heard in near future. Under such circumstances, we are inclined to suspend the sentence.
Well, 52 and 53. My learned friend is in 52. I'm in 53. Well, term imprisonment, 314. Acquitted under 302, 314. 10 years, term imprisonment. You are always on bail. Now, I leave it to your lordship. I must also confess, paper books have been prepared. I must also confess with your lordship. And abortion gone wrong.
Appellants were on bail during trial and did not misuse their liberty. Sentence is one of term imprisonment. He prays for suspension of sentence. Non-lawyer for the state submit appeal is ready for hearing. We have considered the evidence on record. No aggravating circumstance against the appellant is emerging from the said evidence. He was on bail during trial and did not misuse his liberty. Sentence is one of term imprisonment and he has undergone
My lord, from the date of conviction, 1 year, March 23.
he is in custody for more than a year. Full stop. Though paper books are ready, the appeal pertains to 2023, and in view of the pendency of case of appeals, there is little likelihood of it being taken up in near future. Under such circumstances, we are inclined to suspend the sentence of the appellant and enlarge the case.
Grateful.
Yes.
At 54, I am appearing for the applicant.
My lord, 54, my lord, this is the communication, my lord, that was made.
But in earlier occasion, your lordship directed to make communication through the officer in charge to the
All right.
victim. That communication has allegation, my lord, under section 376. And the petitioner is in custody, my lord, 1 year, 7 months.
Appellant is in custody for 1 year, 7 months. Sentence is one of term imprisonment. It is contended that the appellant and victim had a romantic relationship and they cohabited voluntarily. Full stop. Accordingly, appellant seeks suspension of sentence. Learned lawyer for state submit that
DNA report is there. DNA report.
Learned lawyer for the state submit that the appellant refused to marry the victim. Submit victim had become pregnant, but the appellant refused to marry her. Full stop. In spite of notice, nobody appears for the victim. We have considered the evidence on record. PW2 is the victim, right? We have considered the evidence on record. PW1
is the victim.
Is the minor victim. Full stop. She admitted there was a romantic relationship between the parties. Full stop. She had become pregnant, but appellant refused to marry. Full stop. Mere refusal to marry may not give and may not lead to the irresistible inference that the appellant did not intend to marry the victim from the inception of the relationship. Though the victim was minor, it appears that the appellant and the victim were young persons and had intimate relationship out of love. There is
The appellant is married one. 2 children.
married man.
Yes.
Then we are not going to suspend you.
My lord, already, my lord, the appellant, my lord, going to take in the custody of the child also. My lord, that statement is there. My lord, all liability.
Listen, all those things you go and tell social issues. When you are a married person, it's a clear case of dishonesty cohabiting with a minor. All right? We are not going to suspend this. Third paragraph. We have considered the evidence on record. Victim is a minor. Appellant was a married person. Full stop. He cohabited with the minor who became pregnant. Under such, in view of the nature of the crime and the evidence on record, we are not inclined to suspend the sentence. Paper book is paper book ready. Paper books be prepared within 8 weeks. Liberty to mention.
Grateful.
Next.
I am appearing for this state.
I am for the appellant, my lord. But in this matter, out of total 6 witnesses, my lord, conviction under section 21C of the NDPS Act, out of 6 witnesses, the local witnesses turned hostile. My lord, the
Appellant contends local witnesses have not supported the prosecution case. He prays for suspension of the sentence. We have considered learned lawyer for the state opposes the bail prayer. We have considered the evidence on record. Official witnesses have supported the prosecution case. Their ocular version is corroborated by the documentary evidence in the form of Caesar memo.
my lord will kindly see the IO statement. My lord.
Full stop. Mere failure. Independent witnesses result from their earlier statement. Full stop. Their prevaricating stance cannot erode the consistent version of official witnesses. Under such, in view of the aforesaid and statutory restrictions under 37 of NDPS Act, we are not inclined to suspend this.
I'm good.
Paper books be LCRS check. Paper books be prepared within 8 weeks.
Lots.
Next.
I'm for the petitioner, my lord.
What is the matter?
My lord, that this is, my lord, the modification of the condition laid down in the cancellation matter.
All right. Notice has been given to the you are for the de facto complaint. Wants to pray for relaxation. What do you say?
Lordship, they are constantly thread my instructions.
All right,
They are
yeah,
constantly
give a report with regard to compliance.
My lord, already submitted on the earlier occasion.
My lord, the petitioner has complied. My lord, in both the
Yes,
matters,
complied.
charge sheet has been
No
submitted.
adverse report. Then
Lordship, in the other matter, when he got bail, thereafter he attacked the complainant with knife. There has been another case lodged in that.
On that matter, my lord, the charge sheet has been submitted. Charge sheet has been submitted in both the matters, my lord.
323, 325, 307, 506, Lordship.
And my lord, 307 has been removed in the charge sheet. It's waived off in the charge sheet. 307 is not there. The charge sheet has been submitted, my lord.
yes, but then what is the difficulty? You're meeting officer in charge Uluberi of once in a week.
My lord, he's a 70 years old person, first of all, my lord. Secondly, his place
right.
of residence is different and
Report
he
is
is going
placed
to
on
different
record.
area.
Appellant has complied with the condition of bail. It is contended he is a septuagenarian and a lawyer for the de facto complainant contents. There is threat, contents, appellant. There is likelihood that the appellant would threaten her and her lady, her and other witnesses. Having considered the rival submissions at the bar and the report filed on behalf of the state, we are of the opinion condition of bail, that is, to meet officer in charge Uluberi of Women Police Station once in a week is may be modified, and petitioner shall meet officer in charge Uluberi of Women PS once in a month until further orders.
My lord,
other conditions shall continue.
A report may be given.
Shall continue. Next.
Petitioner.
Lord, I am appearing for the NIA, Lord. Lord, kindly grants us, Lord, 2 weeks time, Lord, we will submit a report, Lord.
Report be filed, adjourn 2 weeks.
Granted bail on 13th of.
Can it be on the next day, one day or Tuesday?
1 week.
This is the third time, my lord, the report has not come.
Report be positively filed on the adjourned date. 1 week. Everyone is there in the Ponzi cases.
Mr. Banerjee Malad is on legs, Malad is coming.
Why today MPS has come up?
Well, that application for reduction that we have done, my lord, they have chose to file an opposition. My lord, this is my reply.
Malad, we have not received reply. Malad, we are filing opposition, Malad.
With your lordship's kind permission, my lords, there is can number 39, which is before your lordships today. My lords, in this, the applicant, third party applicant, is landlord, and your lordships were graciously had given liberty to approach the Honorable Justice Talukdar's committee, which the applicant's father approached and got a favorable report, which is placed before your lordships. Now, my shop is closed since 2015. We are today in 2024. And the father who approached before your lordships as a third party applicant earlier has expired, and the son was having the only means to earn. So if your lordship may graciously direct that the shop may be desealed. If your lordship may see the Talukdar's committee, if your lordship pleases to see the Honorable Justice Talukdar's committee's report, which very categorically records that there was a tenant and landlord relationship. And
So how do we ask the reseal and handing over a possession to you?
Well, because I am the rightful owner.
So you get a decree, we will immediately ask the EOW to do.
I just read one.
You have to have a decree, sir. You cannot extinguish a tenancy right.
Malas, may I just, that's why, if your lordship may just have to bear with me. My lord, may I have page 66 for a moment of my application. Let's. Although the report starts at 65, but the Honorable Justice records the directions passed by this Honorable Court and then comes to the finding in paragraph 4 onwards. If I may read to your lordship's convenience, lords. That the undersigned is only a bona fide landlord in respect of the said premises, which was rented out to the said company as its tenant. Such tenancy agreement has also ceased to exist by efflux of time for the present. But because of the fact that the said property has been got to be sealed by Asansol police authorities, the undersigned could not get hold of the possession for its free use and enjoyment. That by keeping the said property sealed and or by not releasing the possession of the same, no purpose.
All right, we'll get a report. Mr. Banerjee, you will appear for the state, right?
Yes.
You know, senior standing counts. We are happy to see you.
It's my pleasure.
What we request you is what you earlier you were appearing. So if you could appear in these matters, we require regular interaction and feedback from the superior officers and all. So that channel of communication is very important. You can deploy one of your juniors. It need not be there always, but have a junior whenever the Ponzi matters are there. Your junior can be there so that we can ask you to come over and assist.
Now, fortunately, Mr. Tulsidas has come back.
Has again come back. So you and Mr. Tulsidas, right? Please take it over. Like the earlier.
And whenever your lordship feels your lordship will call for me, I'll be present.
No, these are like this is an application taken out by a landlord in respect of a tenancy. The tenant was who?
The petitioner company before your lordship.
Which petitioner company?
MPS Greenery Millers. The tenant was, if your lordship may have that tenancy, I have filed the lease deed
let us
as
see
well.
the tenancy agreement. Mr. Banerjee, you will also require to respond to this. You will get everything. You do not have a copy. The
page 55, the lease deed starts, my lord, and relevant would be page 66. 56, I'm so sorry. MPS Greenery Development
MPS Greenery Development. So you give a copy to Mr.
I'll provide.
Amitesh Banerjee as well as Mr. Shotharup Banerjee.
I'll do that.
And let them give their responses. If he has no objection, we will ask
because as far as the
police to deseal and you will take possession.
As far as the petition,
because there is a tenancy right here irrespective of the fact that the term of the tenancy or the lease has expired, to take over possession, it requires you cannot give it directly
I
until and unless
appreciate
there
what
is
is
a
falling from
consent
your lordships.
of the person that he hands over the possession.
Although, I'll just
Mr.
submit.
Shataru Banerjee, please look into it.
I fully
Look into
appreciate.
the tenancy agreement, and if we will record that you have no objection, then the landlord may take over the possession. Correct? But if you feel that this is a valuable asset, etc., and you would like to preserve it, or you have a right and you intend to contest it with regard to the tenancy, then it is another story. All right.
Plus, we are giving the copy inside
Yes.
the court itself. And one relevant what is falling from your lordships, which is very well recorded by Honorable Justice Talukdar in the report itself. If your lordship will see, which I was reading to your lordship's paragraph at page 68, the Honorable Justice report goes ahead. In response to the said direction, the committee issued the intimation to the concerned police authorities, the applicant before the Honorable High Court, as well as the concerned company. This date was fixed up for appearance. I'm so sorry, Milas. I'm so sorry.
No, yes, please.
This date was fixed for appearance with proper documents before this company. So far, the police authorities are concerned, a report has been received being addressed to the nodal officer, Mr. Mitra, intimating thereby that the property in question was found in locked condition. Steps were thereafter taken to lock the door from outside. So what process was adopted, Millers? When the raid was conducted, the premises were locked.
Premises was locked.
And then thereafter...
Lock does not belong to the owner.
Correct, Millers.
Correct.
Correct.
So the possession is not of the owner. To destroy the possession just because police sealed it is not perhaps what you will canvass before us.
No, I won't.
What we need is from MP Greenery's council as to their response on your prayer, and so far as the police's response as to whether they wish to continue the sealing for purposes of investigation or other.
And one, I will trouble only one, what is because this is recorded in this last paragraph at page 68. From our submission, it appears that the portion of the said premises with MPS Greenery by virtue of agreement tenancy executed as far as back in 2010. Once we so and so, son present applicant represented himself as landlord, the categorically mentioned. Now, if I skip 2, 3 lines, the said company was at best a tenant, which is last 4 lines. In respect of the portion, so what is coming from your lordship, I can understand that if he has any tenancy right, that we cannot
need that.
But all that what I was submitting as per the being a landlord, I cannot suffer for the wrongdoing of the tenant, my lords. That principle your lordships are well aware.
We are fully
Yes,
conscious of it.
well aware.
We will get the response whether Mr. Banerjee requires this.
I'm so deeply of that.
What had happened was these people ran away.
Yes, that's right.
They had their shops, various places, cheated people.
Cheated, correct, my lords. That
and
was very
thereafter
unfortunate.
vanished.
It was unfortunate.
Now they have again risen because their main person is on bail. All right. So let us see what is their version now.
My lord may record
Then
that the copies of the application
Yes, copy of the application we handed over to
has been handed over.
Has been handed over to the learned counsels representing the company as well as the state. Their responses may be filed on the adjourned day. Matter will appear 2 weeks hence, or the next day whenever we fix the MPS group of matters.
Very well, man. So I have
Now,
no difficulty.
let us see this.
I'm so deeply
thing.
obliged.
You filed your opposition.
And one more thing, Malas, on the last occasion when this matter came up, your lordship have ordered as if that can 39 has been moved by SEBI for auction of the property. If that may be clarified, because the order reflects can 38 and 39 a common order. Unfortunately, no submissions were made.
Can 39 inadvertent error crept into order dated so and so. Reference to can 39 of the order in the order be deleted.
I am so deeply.
তারপরে তুমি can 39 এই অর্ডারটা করো, হ্যাঁ?
I am so deeply obliged.
Now the affidavit and now it is can 38.
Yes, but can 38 I had filed my opposition.
I
filed my reply.
Reply is given now.
You look into the reply. Affidavit in opposition and reply placed on record. That is what opposition and reply placed on record. We place the when should we place this matter?
Any day, lordship pleases, my lord. I have.
You please. We
Any
please
day,
today.
whenever lordship my subject.
Please today.
I can go through it then and can
Go through it and give us a date. Agree and tell us. The date also.
Well, that injunction is till 29th. We can come back on 29th.
This week we cannot. We'll extend the injunction today.
Oh, then একটা date
29th
বল।
it will not be listed.
Then একটা date বল। আরে date বল না একটা বাবা। No, 20 নে দে, পারবে না।
After today, there will be no Ponzi hearing. It will come up in March. So
Well,
keep
then
it.
Well, 5th March,
7th March, 8th March, whichever lot.
On 14th of March.
14th March, very well.
We will try to keep all Ponzi matters on Thursdays.
Thursday, that is a sir.
May I request if your lordship, since I have to come from Delhi, so I am there in a partnered matter on 14th of March. So if your lordship may
No matter will not be taken up on 14th.
Unless I will
We will keep it on 14th. We will get the responses and then adjourn it to your convenient day.
Yes, my lord,
Let the preliminaries be done.
Very
right, sir.
Very well. I'll try to be there.
And you can access us online if you
I
wish.
am so deeply obliged.
All right.
I am so deeply obliged.
My lord, only thing in my learned friend's application. My lord, do we need to file on affidavit, my lord? Then we'll do that within this time only, my lord.
These are up to you, Mr. Banerjee.
No, my lord, one thing I would pray, my lord, they are opposing reduction of the reserve price. Let them, my lord, come up with the offers which can, my lord, protect the reserve price which is as on today. Otherwise, my lord, the delay is being caused because of this and we are suffering.
Has already been done with Mr. Shatarup Banerjee.
No, that
If he comes up with the better offer, my lord, we are all happy.
Told him that we are absolutely happy you bring up us the better price. We will immediately direct Justice Talukdar's committee to
accept that.
Absolutely. But then what he says is, and we have to consider it before we lower it. Otherwise, it becomes, it will be contrary to due process. He's saying
No,
that.
that's true. But not the basic thing is not to secure the price. If they can secure the price better, that's the best way out.
Correct, Mr. Bhattacharya. We will take that call on 14th.
My lord. My
They are asking for the adjournment. And sir, we will keep your matter on 14th.
I'll try to be here, else I'll join online.
You either join online or physically, or you have any difficulty, we will keep it on another day, but we will get the pleadings on their part or their responses, whatever it may be, on board.
I'm so
So that it would
Then
be
it can
one
be
step
disposed of.
complete.
I'm so
Otherwise, it
deeply
again will push back.
I'm so deeply
Right?
My lord, may I just indicate this as far as CAN 39 is concerned? I understand his anxiety is the landlord. My lord, on 14, my lord gives me 1 week. I'll put it on affidavit whether I require it or not. So that my lordship directs that. I'll put it on affidavit so that about 14 lordship can dispose of this
We
application.
have said response to the application.
Very well.
Why we have said response? Mostly state takes time to file affidavits. So if they give it in the form of a report,
I'll
we will
I'll
acknowledge
file it, my lord.
For you, it is good. Now you are happy.
For
what else? Affidavit, further affidavit.
No, my lord, I want to put it on affidavit so that, my lord, it is helpful to the landlord.
Takes time. So far, that's why we are not specifying affidavit. Then
Very
they'll
well.
say
We'll
that
do
we
it,
have
my
time to
We'll
get affidavit, right?
That will be
Response.
It's going to be
In the
grateful.
form of affidavit, response can be in the form of affidavit, can be in the form of a report for the state.
Very well.
You
We'll
file your affidavit.
I'll file it within 1 week.
Yes, any other matter?
My lord, may I file my opposition to the income tax matter, which is also within time, my lord?
Related income tax CA.
Can 37, my lord.
Can 37.
So ওইটা কথা আমাদের ম্যাট কত
আগে ওই ক্যান যেটা 39 রেকটিফাই হলো ওইখানেও আর ক্যান 36 এ বলো in order dated so and so the tax due has been recorded as so and so, the same be read as so and so. Full stop, affidavit in opposition is placed on.
ফাইল, my lord. আচ্ছা এইটা আমাদের Huh? But now today, my lord, lordship had said, my lord, to serve MAT 512. I had served all of them. This is my affidavit in service. Again, my lord, let there be a direction in that, my lord, for them to file their response, my lord.
We will do it. Not now. Let these be taken into consideration. Thereafter, we'll do.
But may it be kept, my lord, I have served. Lordship had asked us, we'll serve,
What is
my lord.
MAT 512 you have got?
It is, yes, yes. I have served again to them.
All right. SEBI has got it. Mr. Banerjee, have you got it?
No, it is there. I mean, the state has received.
What we'll do is,
My junior would be.
He has got it, my lord.
all right, then affidavit in opposition, MAT 512. Affidavit in opposition be filed within 4 weeks. All right, 6 weeks. Reply 2 weeks.
Very well. আমার তো কিছু নেই।
Yes.
তো করে দিয়েছে। And the interim order needs to be extended.
What is that can?
Can, my lord, ওটার নাম্বারটা বল।
3608.
My lord, না, ওটা তো old can. 3608 of 2015 was the old can. New is can 1 of 2015.
Can 1 of 2015. Huh? Learned Counsel contends that the interim order is expiring on 29th February 2024. Interim order is extended till 31st of March 2024 or until further orders, whichever is certain.
Grateful. Huh? No, can 8. My lord, I am sorry, my lord. The can number is can 8 of 2017 now. এটা একটু বলে দিন না। Can 8 of 2017 now. হ্যাঁ, ওটাই can 8 of 2017. না, old can ছিল 4028 of 2007. 4028 of 2000. Old. 31st March.
31st March.
Can 8 of 2017. ঠিক আছে, এটা ওটা এখন করে নিবি। হ্যাঁ, সত্যি না, গ্রেট না, ওটা হিয়ারিং কাজ করছিস মুশকিলের।
Yes, call the next batch of matters.
Teacher, next.
Call the next batch of matters. Yes, Mr. Pratim.
I am in 66, my lord. On last occasion, my lord has been pleased to direct.
This is in plenary.
Yes.
MPS.
No.
Teacher.
This is teachers holdings.
My lord, I am for the. My lord, I am for the. My lord, I am for the 65, my lord. This is. I have an application.
Who is appearing for the respondent company?
Teachers training, my lord.
Lord, over here, my lord, your lordship had directed 4 persons to be produced, your lordship. As far as 2 persons are concerned, my lord, they have died. I have the death certificate, I can produce them, Mr. Lord. As far as one particular person is concerned, my lord, we have issued a proclamation because he is absconding. We have issued a proclamation. As far as the 4th person is concerned, Lord, we have no details, only his name is there.
Lordship, I am appearing for Papan Kumar Ghosh, Lordship, the direction for personal appearance of one of the.
Yes.
Is present
Papi Kumar Ghosh.
Papi Kumar Ghosh is appearing.
Papan Kumar Ghosh, Lordship. I am appearing for Papan Kumar Ghosh. Number 1.
Papan Ghosh, yes. As far as he is concerned,
Dead person, you are.
no, he's not a dead person.
No, he's not a dead.
He's not a dead. 21, the proclamation, he's the 21. So his
So
proclamation.
proclamation, see,
he
is there your proclamation?
Because nobody has any details of anything.
What
As far
proclamation did you issue? He is there with the learned counsel. You recall the proclamation.
I will do that now that he has appeared.
All right.
Why
was not named in the order.
Let us see the order. One second. Let us see whom we directed to be up.
Item number 63, my lord. Niklas Chakraborty is respond number 90.
Your Lordship directed Swapon Kumar Ghosh, Gopal Datta, Madhusudan Chakraborty, and Bati Ghosh. Madhusudan is dead. And Gopal is also dead. These two persons are dead. হ্যাঁ গোপাল দত্ত।
তুমি এটা টাইপ করেছো?
There is a type of 12 to 24. It
should be what?
22 to 20. 22 to
22 to 24.
First, I got very paranoid with it because, but your Lordship has thereafter mentioned the name, so that's how.
All right.
My name is not there, but that's some of the respondents mentioning of respondent numbers. I asked my client.
No, it's only 20 to 24 because your Lordship has named the persons thereafter.
Because Mr. Ahmed spoke that these 4 persons are not appearing. So, inadvertently, it item number 63. In paragraph 3 of the order, the words respond number 12 to 24 be read as respond numbers 22 to 24. Mr. Banerjee, for the state submit. Respond number 23, Madhusudan.
Madhusudan, number 2, Gopal Datta and Madhusudan Chakraborty.
Number 21, Gopal Datta, and 22, Madhusudan Chakraborty.
These 2 persons have died. Would your Lordship like to keep
Again, the respondent number?
21, my lord, Gopal Datta. 22.
Acha, Swapon Ghosh is respondent number?
Respond number 17.
So it is not 22 to 24. এখান থেকে the words ওটা করো না, issued upon the respondents numbers 12 to 24, the words 12 to 24 be deleted. So respondents be deleted. Mr. Banerjee submits the word numbers 12 to 24 NOS be deleted. Okay. Mr. Banerjee, for the state submits Swapon Kumar Ghosh. Respondent Swapon Kumar Ghosh, respond number 17. And
no, Swapon Ghosh is there. Swapon, Madhusudan, Gopal Datta and Madhusudan Chakraborty.
Gopal Datta, respondent number 21, and Madhusudan Chakraborty, respond 22, have died. Death certificates are placed on record. Petition 1. You have got Madhusudan's death certificate?
Yes, both of them.
Death certificates are placed on record. Petitioners are directed to delete the name of the said respondents from the cause title of the petition. Full stop.
But my lord, our petition serial number is different, my lord.
Yours are
65,
different.
my lord. Swapon Kumar is 20, my lord, and Gopal Datta is 21.
Number diyo na, let us go by names. Just follow the respondents, namely so and so have died. Petitioners are directed to delete the names of the said respondents from the cause title of the petition.
My lord, who will be substituted, my lord? No details.
It's not a question. How can they be substituted? This is not a right where you. How will you substitute in these cases?
Directors.
The liability does not devolve
company.
Company. It is limited, na? If it is a personal property, substitution. In directorship, there is no substitution.
2017, appear
One second. Swapon Kumar Ghosh has appeared.
No, before, but now pursuant to a lordship.
Let Mr.
Pursuant to a lordship's order, he is not available. So many of the police have taken out a proclamation as far as.
Swapon Kumar Ghosh is
Now say that
appearing.
my lieutenant is here now.
So, you instruct your client to appear before Justice Talukdar's committee and participate in the.
What I have inquired from him, Lordship, his address had changed because perhaps therefore the notice did not go to. I will
Correct,
shall indicate
correct.
the correct address to
Mr. Swapon Kumar Ghosh is present in person. Respondent Swapon Kumar is present in person with his lawyer. Full stop. State is directed to recall the processes issued against him on the undertaking that he shall appear before the committee and participate in the proceedings before the committee.
Next comes is Bapi Ghosh, Bapi Kumar Ghosh. So no detail is available of this man.
Yes.
That we could not.
So why should we bother about that? Yes, sir, why? Is there any complaint that she is not appearing before the committee? Very good.
If they need my client's presence, later notice.
Please, Mr. Chakraborty, the husband is dead. You cannot, when the husband has been arrayed as a respondent in the capacity of a director of company, once the husband or the person dies, he has to be deleted from the array of respondents. 1. 2. The spouse or any relation, also a director, participating in the process, continues. There is no complaint against them. On the earlier occasion, it was Mr. Ahmed's statement that these are the 4 persons who were not appearing. That is why a specific direction was given. So in this respect, it is appearing. These Gopal and Madhusudan has expired, so let them be deleted from the list of respondents. Swapon Kumar Ghosh is before us. He will participate on that undertaking. The processes will be withdrawn against him. And now with regard to Bapi Kumar Ghosh, state says that there is no particulars with regard to Bapi Kumar Ghosh. We direct the petitioners to provide necessary particulars with regard to Bapi Kumar Ghosh so that he may be identified and directions are passed upon the state to produce him before this court. All right.
So you should fix the time frame within which they shall give that details.
Mr. Banerjee contends no particulars with regard to respondent Bapi Kumar Ghosh is available in the pleadings. Hence, he could not be traced out. Does Mr. Swapon Kumar Ghosh know where is Bapi Kumar Ghosh? Please talk to him also. See, what is the problem? The wife is there and we have to go to the state, find out whether the husband is dead. Lawyer for the wife knows that the husband is dead, right? So
Particular person is also present.
that's what we are saying. There is a gap. What happened is Mr. Ahmed was there. None of you were present. Mr. Ahmed said these are the 4 persons who are not participating in the proceedings. So we asked the state. Right. So petitioners are directed to supply necessary particulars with regard to Bapi Kumar Ghosh. Petitioners and our respondents are directed to supply necessary particulars relating to Bapi Kumar Ghosh to the state so that he may be contacted and directed to appear before this court on the adjourned date. Matter will appear in the monthly list of April 2024. Presence of Mr. Swapon Kumar Ghosh is noted and dispensed with at present.
My lord, item number 65, one petitioner has died, my lord. I am filed the substitution application, my lord.
Right.
This may be granted, my lord.
Application, is it on record before us today?
Yes, my lord.
Substitution in 65.
Application number 2, my lord, 2023.
Can 2 of 23, 65 একটা order করো। হ্যাঁ।
May I be
65 এ
excused?
WPA number so and so, can 22 in WPA number so and so.
May I be excused? May I be excused? Matter
Wait for
going-
some time.
No, matter is going on over
So
there.
where is your junior? Where is Mr. Tulsi Rai?
One junior is here. Can he?
If he can manage, we have no difficulty.
Petitioner number 6, my lord.
Petitioner number 6 has expired. Application has been made to substitute petitioner 6 by his heirs. Full stop. In view, the prayer is allowed. Necessary amendment to the petition be made within by Monday. By Monday. All right.
Can do.
Not necessary to notify because the applicant. Yes. Any other matter?
Affidavit is submitted.
All right. You take that again, make that effort. So you make a prayer for that. We cannot arbitrarily, unitarily reduce
My
price.
lord, for the time being, we are not going for reduction. We'll try.
Again,
for the-
try
yes.
and thereafter. Don't reduce price
No,
at the
we are
drop
not
of a
going.
hat. All right. So the teachers, all matters will come up in the monthly list of.
In item 66, Lord, I have made the persons likely Anjan Kumar Bhattacharya, Sipra Chakraborty, and Tidip Kumar Das, along with Sopon Kumar Ghosh.
You have give notice to them.
My-
Serve notice first.
My
You can go, Mr. Banerjee.
Correcting the cost title, I have substituted the name.
Please substitute by Monday.
Monday, my lord, petition or my lord by correcting the cost title of the by handwriting, my lord.
Huh?
Correcting the cost title, my lord, by handwriting.
Department, go to the department and make necessary changes.
One thing, Lord, I am praying, let it be recorded in
Item 66.
Yes.
Full stop. Notice be issued upon the private respondents. Affidavit service be filed on the urgent date. Status report on behalf of the committee is placed on record. Other matters we take up at 2 p.m. All right. What other matters are there? Pincon is there. We'll
Yes, my lord.
pass some orders in Pincon. At 2 p.m. we'll take it up.
Just keeping as 2 p.m.
2 p.m.
Grateful.
2 p.m. we'll take it.
বলো তুমি বলো আরে জেনারেল লোক কি আছে
এখন আসেনি কি করে নেক্সট বলো তাহলে আমাদের বলো
So far as the Rose Valley is concerned, my lord, Mr. In one matter, Mr. Bishadu Bhattacharya is appearing. He has said that he has some difficulty at 2 p.m. So can it be on the next date, my lord?
Lord, I have filed the affidavit as desired by your lordship, my lord.
Yes.
Only,
To submit something with regard to the supplement submitted by Mr. Bhattacharya. But yes, my lord, we are to. That is my instruction, sir. Lordship.
Lord, I'll be in some difficulty. And your lordship only desired, my lord, that whether I have acted in my professional capacity, my lord, for the company in question, that I have indicated appended documents to that effect.
Lordship.
Very.
Lordship. Lordship, as your lordship.
Great.
Very
With the exception. That is the actual and the other issue. As
at all. What is written up?
precipitate issue. There is no
That is mere averments they are made in their supplementary agreement, but no documents in support of that they are disclosed. So that will take a little bit of exceptions to these. As well.
But,
What's
why? Want to make one submission?
এই চিট ফান্ডের কেসটা আমাদের সেই 18 সালে আমরা করেছিলাম, হ্যাঁ, কিন্তু একবার এটা ঐকতান, হ্যাঁ, একবার কেসটা কোর্টে উঠেছিল, কিন্তু তারপরে আমরা এখন দেখছি যে কি লিস্টে নেই। তাই এবার হ্যাঁ লিস্টে মানে ইয়ে করেছিলাম, এখানে এসেই দেখলাম যে লিস্টে নেই। তা আমরা আমাদের যে উকিল আছে তাকে বললাম, তুমি 3 বছর ধরে বলছে আমি মেনশন করে দেবো, কিন্তু আর হচ্ছে না। হুম
আমাদের তো আমরা দুটোই
I'm giving at 2 p.m. I have some personal difficulty. I don't think that I have anything to say. Only pin con.
Sanjay Basu matter is also there.
No, Sanjay Basu matter.
করবে না মানে ধরে নিলে কি হবে? What, which matter? My lord, in that matter, we are, my lord, enforcement directorate will find an opposition. My lord, 1 week's time is given. My lord will pass formal orders to. My lord, I was not bothering my lords because everybody is mentioning. My lord, my lord, I shall be there.
স্যার, একটা একটা কথা, আমরা যতজন আচ্ছা
Your matters. You want to do it today?
One of my junior who is.
You said that.
He's also today also he's not.
No, you told us. That is why we are starting by
Exactly.
saying.
He's also today not.
Can you agree we can give one date? There's other matters we take.
Monday would it be possible, my lord?
No. Next week.
Friday week?
Next week I am not there.
Okay. Then after that.
So we keep it in the in March. We can give you one.
No problem. Lord. First week of March would you also available? No.
No, I am available. Brother. It's not. This bench will not be available till 15th of March.
15th. After 15th.
What is happening is next week I am not here.
Correct. At least 2 weeks you'll not be here.
One week. I am not here. Then brother is not here up to 15th.
One of the
So let us do like this, Mr. Bandhavata. We keep it in the second week of March. Thereafter, let us see start, and then after brother comes, we can pass.
Second week of March, my lord would not be here.
I'm in Jalpaigur.
My lord would not be here.
Brother is not here up to 15th. But post 15th, I think you may have some difficulty, right?
No, after 15th, I have
That is
to
what
be here.
I'm saying.
Post 15th, yes.
Let us keep like this, Mr. Bandhavata. Let us keep these matters on the 18th or 19th of March. All right.
18th is all right.
18 March.
Post 15 থাকবেন না একটু অসুবিধা আছে নোটিফিকেশনটা হয়ে গেল লেটস সি 18 মার্চ বলে
Before that,
Before that, the problem is this bench is not here. Justice Kant is not available in the first 2 weeks of March. I am not there next week.
March will not be available.
I was very hopeful, my lord. I could have started today for my side, but then
No, junior. No,
if you start, we will have to post it up.
My lord is saying even if I start, the result would be.
Day before yesterday, in fact, Mr. Bandhavata indicated to us that there will be some problem today. So we said, let the matters come up. After the matters come up, we post it. All right, we'll keep it on 18th. Let us do like this. Even if Mr. Bandhavata is in some difficulty, Mr. Ratnako Banerjee can start. And Mr. Bandhavata, you can join in online.
Let's see, let's see.
Or we can.
I will be in the remote places. And
you will be in remote places. That is also true. That is also true. All right.
Anyway, let me try on 18th. If it's not there, I will not be there. Mr. Banerjee will.
Let Mr. Bandhavata, Mr. Banerjee start it. All right, Mr. Banerjee. Yes. For you, complainant, you wanted to put in objection.
Should we file it today, my lord? Should we file it today with the court?
Please file it today so that they can respond to it. Mr. Bandhavata, Mr. Banerjee, objections are being filed on behalf of the complainants. So, if necessary, within 2 weeks, you file your replies.
It has been served upon.
That's why we said.
Nothing new, same.
Whatever it may be, let them. If necessary, you choose to file your rejoinders to the oppositions, do. If not, we will go on these pleadings. Affidavit in opposition is filed on behalf of the de facto complainant. Rejoinder, if any, be filed within 2 weeks. On the consent of parties, matter is taken, shall appear on 18th of March.
At 2 p.m. If it is 2 p.m., I can try.
2 p.m. We'll keep it at 2 p.m. or 2:30, whatever.
My lord, I am for one of the victims who's just entering appearance. My lord, we may also, my lord, be given some time, perhaps a week, to put in our objections, my lord.
This matter has been pending.
Then please tell us in which matters are you filing objection?
I've stated in which matters am I appearing and I've filed.
No, another gentleman who was saying.
Someone is saying that in which matter you are appearing?
Item 33. Item 33, my lord.
33. So, Item 33, record an order. Learned counsel for the victim seeks time to file opposition. Opposition be filed within 1 week. All right. You file your opposition within 1 week.
Within a week, madam.
Within a week.
Within a week.
Reply 2 weeks, 1 week thereafter.
Yes.
1 week thereafter. And from 34 to
which
45, where have you filed opposition? Which matters? All matters you have filed. That is, we are recording orders. You are not even aware which matter who is.
For item number 33, the 37, 38, 39, 41, 43, 45. These
33, 37,
33, 37, 38, 39.
39,
41, 43, 45.
41, 43, 45. So these oppositions are being filed.
Yes.
Others opposition are not being filed. Has not been filed. You are in 34.
But I was told 33, my lord. Now I'm going to understand that there was an error. I will just clarify that, my lord. I will just clarify, my lord.
We have not got opposition for
all the matters. We
Mr.
have
Let us make this clear.
a second.
Which cases they are filing opposition, which case they.
My lord, I'll indicate your lordship's officer. My lord, in a chart, I'll indicate your lordship's officer. In which of the matters, my lord, I'll be because, my lord, there is.
All right.
Because the police has, my lord, served upon us, and that number matches with item 33.
Sir, please settle it amongst yourselves. We have no problem. We'll record order, incorrect entries will be made. In so and so case, affidavit is being filed. Affidavit will not be there on that case. You don't have to tell us, make a list and give it to our officer.
We will do that.
ওরা যে লিস্টটা দিল, affidavit in opposition is placed on record. These are cases where Mr. Mitro is appearing, Mr. Dotto is appearing. Affidavit in opposition is placed on record. Reply, if any, by 2 weeks. Other cases, after learned counsel seeks time to file affidavit in opposition. Opposition be filed within 1 week.
Within 1.
Reply, if any, 1 week thereafter. All right. This will be the 2 batches of. This covers the entire batch. All right. On consent of parties, matter is coming on 18. 2 p.m.
But only 4 affidavits you have served us. Develop listed.
Grateful. Yes. Now call Ponzi matter.
I'm grateful, my lord.
Yes, call PinCon. 68 to 73.
Well, 68, there is a can number 3. ওটা একটু দিন না
Can 3.
ওই 24,110 একটা can 3 ফাইল আছে।
State lawyer is not there.
As far as 69 is.
Now Tulsi Das will come. We talked with Mr. Amitesh Banerjee. I've said Mr. Amitesh Banerjee and Mr. Tulsi Das. You are busy temple matters, so no, there are no other temple for you now. Inner temple, outer temple, all gone. When are you handing over charge? Huh?
As per rules of the party.
As per rules of parliament. Sixth.
My lord, in this matter, what happened? 6 crores were directed to be deposited with the Registrar General. We had deposited 6 crores, out of which your lordship, taking Ponzi matters, directed 4.50 crores to be transferred to one-man committee. So it should have been left 1.50 crores with interest to be. Now, my lord, they filed a report. The Registrar General has filed a report, my lord. Pursuant to your lordship's direction, that, my lord, they have 1.12 crores and some interest, which comes to about 1.3 crore, 3-4 crores. So they say that the bank had mismanaged everything and bank had made a mistake.
What mistake?
What happened? Instead of sending 4.50 crores to the one-man committee, they sent extra money.
Extra amount. So money is accounted.
That we don't know, but what happened, whatever may be the situation, my lord, let whatever money lying with the Registrar General be transferred to one.
Let us find out whether 4.7 odd crore was sent to the one-man committee or not.
No, 5.06 crores. They say, my lord, may I just indicate?
That is the report of the registrar.
Registrar General একটা report আছে দেখুন. It was filed on, my lord.
Who is appearing for High Court administration?
Mr. Nag, Orko Kumar Nag was appearing on the other day.
You are appearing for ED.
Balaram.
In this matter, my lord,
You are for
this is with regard to number 69.
69 will come later.
My lord, 68, I'm not there.
69 will come later.
My lord, 68, we are not. I'm not.
All of you are in 69.
Yes, my lord. I'm-
এইটা দেখুন। Let us kindly come to page 28, the bank's reply.
Paragraph 8.
Paragraph
8. Page 5.
Yes, instead of
So remainder amount?
along with interest accrued thereon, my lord. They say, the bank says that 1.34 crores is lying with them. That is at page 28. Page 7 also, my lord. But this is, my lord, the calculation till April 2023. There must have been some addition also thereafter. Page 28, my lord, they cleared it. They tried to explain it. $5.06
All right. Peruse the report of the Registrar General. From the report, it appears a sum of 5 crore, 6 lakh so and so, huh?
5.06
Page 28 থেকে, was transferred from the report. It appears, though this court had directed transfer of rupees 4 crore 64 lakh 31,846 to the one-man committee, comma, the bank authorities had transferred a sum of rupees 5 crore 6 lakh 52,923 to the one-man committee, to the said committee, out of 6 crore 19 lakh 19,128, which was standing, which had accrued against 28 FDs of the respondent company.
Till 20th of February 2020.
Yes.
That was the amount then.
That amount, so much was transferred.
I understand.
Was transferred on 20th of February 2020. Huh? An amount of 1 crore 12 lakhs 56,205 remained outstanding, and interest thereon as on 26/4/2022 amounts to, and with interest added thereon till 26 to remained outstanding. Under such circumstances, we direct the remainder amount with interest thereon, accrued till date, be transferred to the one-man committee. Full stop. Report in this regard be filed on the adjourned date. Matter will, whenever we give them.
When the matter has been PINCON matter has been directed to be appear in monthly list of May.
Registrar General shall submit report.
Transfers within some date, some within 2 weeks, 3 weeks.
Within 1 week of communication of this order.
May I please, Your Lordship? My Lord, in WPO.
এটা হয়নি দাঁড়া, এটা হয়ে যাক 489 টা।
So this will be learned counsel for the respondent is directed to communicate this order to the Registrar General as well as the concerned bank.
I shall.
Concerned bank concerned shall transfer the order with the amount within 1 week from the communication of this order. Registrar General shall submit report on the adjourned date. All right, your plan is
yes, ma'am.
As of now.
Can.
On the next date of hearing. Adjourned date next date of hearing.
Your Lordship, on the last occasion, directed my learned friend to serve a copy of WP number 489.
Yes, my original side matter. Your Lordship, on the last occasion, my Lord has pointed out my learned senior friend that the copy of the writ petition is to be served upon all the respondents. My Lord, due to some difficulties, we haven't been able to serve the copy. My Lord, I pray for 1 week's extension, my Lord.
May.
Grateful.
All will come on May. Effect your service.
Yes.
Yes. Any other PINCON matter which requires orders to be passed? 69, Mr. Trivedi.
My Lord will address me as Dheeraj Miller. Remembers me.
That is
Lordship, in this matter.
Generally forget surname.
My Lord,
No, all of you
what
but first
happens,
name.
my Lord will not take judicial notice. My Lord has seen me as a young member of the
Yes.
bar. So, my Lord, that habits die hard. So, when habits die hard, if my learned senior friend addresses me, he knows me from law college days, my Lord. So, basically, we all age together. So, that is the main problem, my Lord, why the habits. My Lord, in this matter, my Lord, I am praying for 1 week's time, my Lord. Our affidavit.
By the next date of hearing.
My Lord, our affidavit in opposition will be served in the
on the prayer of Deputy Solicitor General seeks time to file affidavit. Affidavits be filed by the next date of hearing.
I'm grateful.
You're keeping all these matters go en bloc. So now we kept it in May again. In the
Deeply.
meantime,
I'm grateful.
there's only one thing, Madam. The third, until and unless if there is some urgency, please mention or take out any application. You want further orders or something, take out.
Hello.
Yes, Mr. Ganguly.
No, my lord, Mr. Banerjee, I would like to address your lordship on one issue, my lord. Just seize this order for a minute. Seize the third name. This is on a lighter note, my lord. Very lighter note. Seize the third name. I think spelling, if the third name, my lord, from the petitioners, the third name, substitute the word A with H. One. It becomes the virus. I wish I
That
could.
is he.
He's not here. He's in Joymalya. That he was yesterday or
He went for a holiday or something.
No, no, no.
Or tanned and all.
Yes, he had gone for a holiday.
Yeah, then why are you suppressing it? We are not ED. We're not going to issue a notice upon you as to from where did you get the money. It's so distressing what has happened. Another matter, SFIU has issued a notice upon lawyer. 10 years income tax return you produce. You stay, we've asked them to adjourn.
SFIU companies actor. SFIU lawyer.
Oh, the serious fraud
Lawyer connected to the company. Yes.
The problem was what the learned counsel said very fairly, that we were not aware of the relationship. There was a large amount transferred. So in order to get a clarification, we have given a notice.
Yes, I know that.
We had to assume jurisdiction is because we had set up a committee. Committee is headed by a former judge of this court and Allahabad Court, High Court. And this person is a member of the committee. So he is acting more like the representative of the court, and he has been issued a summons. So he took out an application in these pending proceedings saying that how can I be summoned? So then they gave us in secret sealed cover certain documents. So we have asked him to clarify your professional role with regard to the company, and we have asked the authority also to respond and said that if these documents are genuine, then you take a reconsidered decision as to whether you require an explanation of transfer of funds. Because that will, we have not heard it further, but this is a question we need to address here, that whether a monetary transaction, transfer of funds between a person who is a legal professional having a legal relationship with an entity which is under investigation will be covered by 126 of Evidence Act, that is the client and lawyer privilege. How much fee I have paid to my lawyer?
Very pertinent,
This is
because
an
most of the
important
time,
question we need to
the members of our bar who are practicing on the criminal side, we are engaged, who may have anticipated.
Side gray area. All right.
I take that, I want to be very
check. But the thing is, whenever you have a client who is a corporate entity, no payment beyond a particular limit is done in cash.
That is a finance sector.
Money transfer, check, whatever it may be. Now, if a solicitor firm or a lawyer who is acting not only as a counsel but also as an advocate on record, there is a possibility of large transfers, right? Let us say if there is a big litigation and on account there is a transfer of 1 crore. His fee may be 20 lakhs out of it. It may be senior's fee, other expenses. So this is where whether an investigation can go into that area, which we have asked that let us factually see whether the relationship was subsisting when you gave the notice. And if you give the notice during subsistence of relationship, then this question you have to answer as to whether the legal professional can be questioned by SFIO on this. So it is an interesting issue. That's why
it is.
But two lessons therefrom, that we are required to draw up our bills immediately after every date when we appear. That is the lesson I gained from this. It should not become
also draw up your bills, keeping in mind the uploaded orders whether your name is appeared.
Yes, Milord.
Well, that is usually secured by the client.
There is a big problem. The name is not appearing, bill is drawn up, solicitor writes a comment.
Now,
you are
Milord,
absent.
because of live
But now
streaming.
this
Live
helps.
streaming is also one of the reasons that.
But it goes against us also sometimes.
We were not there. You were not
live
there.
streaming, Milord, everybody can see, Milord, whether we are appearing or not.
No, in earlier times, nobody would generally question a senior whether he was physically present. Someone was there, it was good enough. But today, you just don't know when a very unpleasant, unpalatable question crops up, etc. If the bills are being raised, he's not present, his name is. Which is why I always say to the juniors, when large number of lawyers are appearing, please check out all the names are entered or not. Otherwise, it makes it very embarrassing. Someone name is not there. And
Well, in fact, when the company goes the CIRP procedure, well, letters sometimes come to us. This amount has been paid to you. Please clarify.
This is what we are trying to go into. If a person, Mr. Shobik Nondi was appeared. Mr. Nondi, on the first occasion when the application was made, he took up this point that why you were there. He took up this point that why this court is assuming jurisdiction, he should move. Then we said that we would have otherwise not taken cognizance of this, but he's a member of a committee who is a representative of this court. It's like a special officer acting on our behalf. So if you are taking step against a special officer, we definitely have the right to invoke jurisdiction and check out whether the exercise is valid or not. And this has thrown up an interesting question. They were very fair. The officer was extremely decent. He came, saw. Then we asked the learned counsel to clarify the position. Then we kept it that you take a call on that. If it is legal, personally speaking, I feel this degree of investigation also the law puts an embargo. That lawyer-client, you should not go into this inquiry. Otherwise, it becomes very embarrassing. As Mr. Ganguly says, today if you give a notice, then you have to send someone with a letter that these are the bills, I have cleared this.
I had to do one.
And so nowadays,
to find it out
he's like
5 years,
Mr.
6 years
Ganguly,
back.
Mr. Banerjee.
Very meager,
They are
my lord.
very
meager, my
large
considering
fees.
other-
should have seen the
Large
previous
fees.
people who were appearing there.
Not for Mr. Dheeraj Trivedi and the government.
And that
Your fees today are no less.
Compared to the
Yeah, but
rest of India, I
I
think.
feel proud about that. And speaking for myself, I feel proud that our next generation is not being starved with low fee
So that is
structures. But in Calcutta, the fee structure is the
lowest.
Because
Milord,
brother tells me in Delhi, there is no comparison between them.
we are also to blame, Milord. We are very humanitarian.
I don't know.
I say, my lord will not. My lord, may I speak? Milord, acha hoye jabe kono অসুবিধা একজন. Most of the times we say, and my lord,
it all happens is because of the practices which are adopted. The fee structure, particularly in Calcutta, in the appellate side, was always not a very healthy one.
No.
And then,
Milord, we juniors are also to blame, Milord. If today there have been optimum number of
people like
occasions
us were to blame.
when Milord we had engaged your lordship, we have engaged my lord, and the money was never a consideration.
During our days in the bar, we are also to blame that we did not enhance our fees and allow the fee structure to grow up. But then, as you said, it was always a question of the client accountability.
We also love
persons coming from the hinterland.
This is not a region which is really
economically
rich in cash. So
the corporate houses are not there as far as because who actually pay, Milord, who can pay
what
the bills.
happens is, as I again stress, in the original side, the main litigations are company litigations. In the appellate side, what you will find, it will be either certain poor farmers, family having matrimonial domestic disputes. You will have dismissed employees. You will have workmen. So these strata of society who are not able to meet up to the requirements of a high fee structure. And that pull down. That
Definitely. If hinterland people won't be able to pay that much. That
That
is
would-
definitely.
So you should have two fee structures. One for the weaker sections of society, including marginal sections, and another for the not so weak sections of society. They do? Oh. Ah. Brother has given some input on this. Brother says that
Privilege.
outstation cases come to capital
yes, of
lawyers. The fee structure is always high.
Well, privileged communication.
From privileged communications, right?
Will not delve
They should
into it.
remain privileged. But it's good. It's good with a healthy fee structure. What happens is, it gives opportunity for growth and hard work.
And we can work in a better way.
Hard work.
Hard work
Sir,
and
Sir Dheeraj, what
be
is
more-
happening is, if your fee structure is weak, the lawyer tends to take more cases.
Yes.
So the proportionate time devoted by him to one case is reduced. But if he's got a reasonably good fee structure, he can really devote himself to a particular case, and the quality of
That is-
research advocacy goes up. There is no-
But unless the council, who was charging less, had immense intellectual capability to handle that amount of briefs also. Well, I really could not. I could not handle that.
You cannot. You cannot, Mr. What you have done is very good. There are two aspects of it. Firstly, it is your health, because it would have an immense toll on your health. And I can tell it from my personal experience. It has immense toll on your health, because on an average, Mr. Ganguly, you are appearing in 10 matters. So in 10 matters, let us say there are 4 matters, there will be an adjournment. 6 matters, you have to come prepared. And the problem with a lawyer, it's a roulette.
Yes, which one will
You don't know which one is going to be adjourned, which one is going to be argued. So you have to be fully ready in all these. So the pressure is quite high. And if you take it for 2 years or 3 years, it's going to have a toll on you. So it is good that you hike the fee, reduce the work. And the second aspect is, it gives the space for the younger lot to grow.
The most important.
It gives space for the
We did it together, in fact. Whenever we increase it together to ensure that the juniors also increase it together.
juniors also increase it.
The juniors, our Chairman juniors
But
are
Mr.
also aligned.
Bhattacharya does
No,
not.
no, he does the same thing. He's been told, otherwise he'll be out of our books.
Oh, he is out of the book.
He has to increase it parallelly so that his juniors also increase it.
Achha.
The cartel practices should not be discussed over here.
No, you don't let out all your secrets.
No,
Thank
but
you.
it's also at the end of the day a service industry, my lord. We are
We are very happy, Mr. Ganguly. Both you, Mr. Banerjee, I think Mr. Bhattacharya also. We are getting your services in the legal aid, legal services.
Yes.
No.
You are not there, no?
No, I'll join.
No. We'll see that from next week you are.
No,
that will be done so that you will have. And the other thing, we've also requested the Chief Justice, we need senior advocates ordinarily practicing criminal law.
Yeah.
Otherwise, the death reference cases, as per the Supreme Court judgment, we need to give to senior advocates.
I am already there in 2.
I know you can't take so many, right? So I can't burden now Mr. Sudipto Moitro and Mr. Basu. Mr. Dastur is ill.
Yes, there's not.
He's not coming on.
We have to decide.
And now I can tell it.
Those are my.
I gather it's pending, my lord.
No, we have talked. I personally talked with the Honorable Chief Justice on the issue of having our legal aid panel ramped up. The legal aid panel needs more senior advocate, particularly when we are assigning the serious appeal cases where death reference is there. Only one, Mr. Ganguly is. One we brought in Mr. Prabal Mukherjee.
Yes.
Yes.
And I was,
I was
yes.
I requested Mr. Prabal Mukherjee. He was very embarrassed. He said, "How will I do it?" I said that your junior is there, Vishwas there. Sriyoshi Vishwas was there, and then we are there from the bench. You argue the case.
No, but he did some criminal matters at least.
But
Very
it's a
these
whole different story.
125 these.
Those were more
Yes.
matrimonial and civil
Yes,
related,
connected.
not really criminal cases where conviction on death reference.
No, that he has not.
That is a different story. We'll hope that we'll get more senior advocates.
Well, let's
in as quick
let's
as
there's
yes.
hope there's need for congratulations very soon. Thank you, Mr. Ganguly.
Yes, Mr. Banerjee. Mr.
We are all keeping our fingers crossed.
Dheeraj is also there. So Dheeraj is also there. So we'll see. Hopefully we'll have more
We are keeping
senior
our fingers
advocates
crossed.
to assist us in the bar. Thank you.
Well,
Next
Hello,
one.
sir.
You give your response and we keep it in smart. Huh?
Okay.
Can. What is the can, Mr. A?
Milord, can number 8.
Can number 8, Lordship.
Can 8, right?
Yes, Milord.
Can 8 of Swanso after Mr.
Mr. Tiwari. Shailendra Tiwari.
Mr. Tiwari. Mr. Tiwari seeks time to file rejoinder to the file response to the supplementary affidavit.
I am filing the
Supplementary affidavit is placed on record. Rejoinder be filed within 4 weeks. Matter will appear in the monthly list of April 2020. All right. Acha, what about your website?
The website is set for being taken.
That order was placed before the committee.
Yes, Milord.
So when do you expect the website to be functional? All right, so we keep all these matters in the monthly list of April. The next council for the committee shall submit report with regard to the operationalization of the website.
Milord, in Rose Valley matter, there are
yes.
There is one of my application is for transfer of fund by the ED. That matter may be kept in the month middle of the March, Milord. This is a separate matter.
All will come in April because for major part of month, first half of March, brother is not there.
Yes.
So we'll list all the matters post 15th of March. So we do not wish to burden the list. Other matters are coming up. So other group companies will be considered. You will be considered in April.
April.
Because Mr. Partho Ghosh requires to be heard on that matter.
Yes. Mr. Partho.
Yes. Mr. Trivedi, we need assistance how to work out. Let us look like this. Huh? The practical problem is the law under PMLA. It's an embargo because it is the special court. Now, if the court can assign the committee the responsibility.
About an application. I was online. Wanted to put but that particular order, that aspect was not touched because there is already a substituting order where it has been said that taken order with regard to the amount which is that was to be done by the PMLA court under section.
PMLA court under section 8, whenever they entertain any application, may refer it to the committee as the representative of. All right, you can clarify that. Because what will happen is, how many PMLA courts you have? Yes, because in multiple PMLA courts, it will create a bit of a conflict of orders. So we should lay down a certain guideline how the PMLA court is going to entertain the application and deal with it. It can entertain, and for vetting, it can send to the one-man committee and will act on the recommendations made by the one-man committee. That way we can do. So let us work out a formula through which, without doing violation to the provisions of the law, we can have the most convenient forum and process for repayment, right? And another problem, auction. PMLA courts don't have the permissions for auction. To sell and give the fund, we have to refer it to SEBI and the one-man company. SEBI has that wherewithal. Please look into these aspects, Mr. Yes, no, these are just what are coming across in our mind. You also apply, and because it's not a case of adversarial exercise. We are trying to sort of collaborate the situation and create the best possible avenues of mobilization of use for 30%. We can do that, it will be very good. All right, we will work on it. You see, there is no fee. Why are you so eager? Huh?
One thing, Milord, I was.
There is. This is pro bono.
Yes.
Or you are
No, no,
also
no.
professional. You don't know.
No, I have not learned that from my.
What all those things whatever today we are busy.
Sir, your lordship has
You
been
are
my
busy
teacher.
counsel.
Your
You are
lordship has been
busy
my
counsel,
teacher.
but your time is very
Milord, Justice Kant will not recall, Milord, he will not know. I know, Milord. I know, Milord.
more
The entire, Milord.
about you.
The Takwani's book was, Milord.
Takwani and all
Here,
that.
was here. Administrative law, Milord, I will never forget.
Yes.
And Milord, ADM Jabbalpur's judgment, the explanation offered by your lordship, Milord, those rings even today in law college. Milord, I have not learned. I have not learned.
You may not, but you are very busy, extremely precious time. So don't waste it.
Milord, I asked Milord, persuaded the circuit bench, convinced.
Still here.
Only one thing, Milord, I was wrong.
Painfully.
I was wrong. Only one statement, I was wrong. Milord, I indicated, Milord, in the first half that I have appended documents evincing that I was engaged in a professional capacity. That document I have craved leave because it's a privileged document. Why? Because there are certain internal communications made by the client with me, indicating the SEBI's notice.
You redact that and enclose.
Yes. Milord, I am giving my learned friend
That's way you will not do. If you file a supplementary affidavit,
very well, very
enclose those communication, redact the relevant portion, the portions you don't want to disclose.
Very
right.
Very
All right.
Kindly
Mr. Bhattacharya, please re-record the order. Can so and so. Mr. Bhattacharya submits supplementary he seeks leave to file documents. He seeks leave to file documents. He leaves to file letters showing exchange of views between his client and the company concerned, subject to redacting portions of the said document. Leave is granted. Leave is what is cholo?
That portion had to be
Order is over. Leave is granted. Supplementary affidavit enclosing the document shall be filed within a week.
Right.
All right. Response to the affidavit, supplementary affidavits shall be filed within 2 weeks.
Yes.
Matter will appear in the monthly list of April 2020. Subcommittee of the that in our order we have.
Yes, that is recorded in the previous.
No. Forget it's the subcommittee. ADC is the ED, the Honorable Judge, ED, and another representative of SEBI, state representative, and he is a member of the subcommittee. All right. Learned counsel for the committee submits that the website shall be functional shortly. He shall submit report with regard to the operationalization of the website on the next date of year. All right?
Great.
Now you go.
Brother. Brother. So it's not that. So it's
Honestly speaking, Milord, I was, Milord, when it was shown to me, Milord, no. Honestly speaking, I was under the impression it is annexed. And then, no. I take it on my shoulders. It is my mistake. It is my mistake. It is my mistake. Become nothing, Milord. I knew that I do not know. Milord, honestly, Milord, I'll tell you, Lordship, what has happened. Whenever. No. Milord, the affidavit was shown to me. I had vetted it. I had corrected it. I had indicated that this has to be incorporated. Now there's a change. Milord, Milord, when the change was supposed to be shown, I thought that it was the same affidavit. I did not look into it. I'm telling you, Lordship, that is exactly what has happened. And I was under the impression it's appended. So I was, Milord, wrong. When it was shown, Milord, suppose not intentional.
We have told this about documents for support of the scheme of the
Lordship.
let's say that it is not another action. Enclosing documents showing that
Lordship.
after redacting portions of the document in order to maintain continuity.
Great.
Very good. And if necessary, we shall file an application for exception if necessary. In affidavit, in form of affidavit.
বলেছে এপ্রিল মাসে আসবে
Lordship. Very good.
মানে টেন্ডারিং আনকোয়ালিফাইড অ্যাপার্ট
Lordship. He's always busy. That's a good thing and good news for all of us.
দাদা লিখে দিয়ে দিয়েছিল ওরা নিজে থেকে রিভিউ করে দিয়ে দাদা ওই ইমপ্রেশন আছে কি ওখানে ডকুমেন্টস রয়েছে এটাই দাদা বলি
I cannot answer Milord everything. Milord, I take it on my shoulder.
I have also given one offer to him, to my junior friend, in other way. Right.
আমাকে মুখ খুলিও না কিন্তু গ্রেটফুল